now. Who gets in the bar with us?
Can you?
Sure. That's all. I need to go down to the hall.
Hello,
Morning, good.
thank you so much.
What happened? Something happened?
She said there was a storm, so all of the electricity is out in her area.
Uh-huh.
And I'm like, we didn't get that storm,
No, it's travel. Yeah, she lives in the.
so. And
Okay.
then now, guess what has happened?
We have.
The bus to the jail,
Uh,
to and from the jail, broke
Can I
down.
come back and turn?
So we're waiting.
Be back at 1:30.
Well, she left all her stuff here and it's a lot of equipment.
Oh,
I really don't like touching anybody's stuff.
okay, we're gonna see if we need anything.
And just, we are gonna start with the trial first, right?
Yes, but I'm gonna call Docket.
Well, we have several parties.
All right, everyone. So there are a couple of things that are going on this morning, so you need to be patient. And it's out of people's control. And all we can do is determine how we're going to react to life's adversities. And it could always be worse. So this is what's going on. Number one, attorneys and family members. The bus that is transporting people from the Bexar County Jail has broken down. What does that mean? I don't know. Maybe they were not pulling appropriate maintenance on the bus. You know, my brothers always told me, Stephanie, your car is brand new. All you have to do, just take it in, get the oil changed, let them check everything. You should be fine. So I always do that. I don't know if they did that with the bus or not. I don't know if it's the transmission, the catalytic converter. I don't know if the tires, I don't know what's going on with it. But I know that yesterday a bus broke down. They had to have it towed. I don't know if this is the same bus or not. So attorneys, you're gonna have to be patient. The deputy, they'll let you know if your client made it on the first bus or not. So that's where we are. We're going to start up a jury trial. We have a court reporter that's going to be sitting in because I received a text message from Cindy. They had a storm in their area, so electricity is all out. Now, I don't know why the government just doesn't decide that there should be a different way to lay power lines so that when storm hits, you don't get the transformers exploding or not. But hey, that's outside my purview. So I'm going to call the docket. When I call the docket, I need you to stand and let me know you're here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. So we're starting, you shall see, with closing arguments for jury trial. Then anyone else that wants your trial will do jury selection in the afternoon. All right, Tiffany Martinez. Roger Mims. Isaac Valle. Do I put the S on that or no? Oh, no S. The S is silent. Okay. Isaac Joel Valle. Did I do that? Valles? You told me the S was okay. Isaac Joel Valles.
But I'm proud that you said the double L.
All right, thank you. The double L gets me every time. Tyrell Benjamin.
Here.
Thank you. Jamarian Tyrese Marquise Greer. Thank you. 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 Mason, Washington, custody, Jacob Leal. Thank you. Kenneth Howie, custody. Eddie Law Outlaw. Eddie Law Outlaw. Isn't that a cool name? You got the law part, but then the outlaw, so. Yeah. Alfredo Campos, custody. Marcus Tremaine Butler. Thank you. Roger Luis Blanco. Chase Anthony Lopez. Fernando Leal, custody. Adam Bazan. Carlos Vasquez Saldana, custody. Jonathan Alfonso de Hoyos.
Here.
Thank you. Valerie Campion.
Here.
Thank you. Isaac Valles.
That's the one that I sent you a message yesterday.
Oh, that is so true. Thank you. Diane, can I have that file pull? Diana LeCompton. Thank you. Rodolfo Brasinho. Rodolfo Brasinho III. Valerie Campion, I'm sorry, you're on the docket twice. Albert Estrada, custody. Teresa Frias. Thank you. Malik Lampkin, custody. Roger Luis Blanco. Tyler Ashbaugh. I think that was taken care of, wasn't it?
Yesterday, yes, you're.
Okay. Anel Yaslin Soto Figueroa. Soto Figueroa.
I represent her. I'll give her a call to inquire as to whereabouts.
Thank you. Curtis Ray Wilson. Thank you. Anthony Villarreal Jr. Luis Beltran, custody. Renee Camarillo, custody. Thank you. Marco Marino, custody. Jesus Ares Mendez, custody. Marquise Trayvon Berry, custody. Dino Acosta. Dino Acosta. I'll take care of that today. Emilio Lopez.
Present counsel.
Thank you. Jose Rendon, custody. Howie, custody. Jesus Antonio Santoa. I know I'm mispronouncing that. How you say the last name?
Santola?
Oh, yay. And he's not even here to hear it. All right, is there anyone who came in later? Your name was not called. All right, everyone, these are the rules. Please follow these rules. For the people in the audience, you are not allowed to speak to any of the inmates for security reasons. If you speak to them, you're just going to be tapped on your shoulder and the deputy is going to ask you to leave. And you will not be allowed back in this courtroom unless you're called as a witness. So those of you who are on the docket, don't think that's a way to get out of having your case heard. There will be other things that will be done. So don't do that. Attorneys, I've already explained the issue with the bus. If you have somebody who is on bond, make sure you confer. The deputies will make sure that people who have inmates. Thank you. The deputy will make sure that the inmates will be brought over as quickly as possible. So we're doing the best we can. Do not talk behind the court reporter. You're not ready to approach the court if you have not conferred with the state and conferred with your client. Guys, be kind to each other. It's going to be a crazy day today because nothing is flowing as it should because the bus has broken down. All right, everyone, please confer. And to the parties on Rodriguez, we're just waiting. Are you all going to need any exhibits for closings?
I don't believe so.
All right, we'll see if we can get the photographs for you. Usually the court reporters have the key to the safe. Okay.
Next week.
Thank you.
What's your name? What's your name?
I don't know if I have it.
Oh, we do. Yeah.
The
Norma?
Yes, ma'am.
It's gonna be a great day. Yeah.
How does that look?
Well, I know it's Warrant.
Then as soon as he gets here, we'll take him up first.
this year.
Yeah, for that guy.
Mhm.
Oh, walk there.
Judge, I've been authorized to do this.
Oh,
I'm
sure.
not coming to get you.
Okay.
What is this? It is.
Give it that.
Yeah.
He didn't come.
It's not.
Oh, LaShawn, you found the scent?
They're coming down?
Yeah.
Oh, my God. When I get you to the bus, you're gonna have one house.
Yeah, they say there's gonna be a major storm, so. Yeah.
We're holding.
All right, Norma, I need a 30-day reset on Valles. Yes.
With me on July 10th.
All right.
Assuming. I'll even take them down.
Yeah.
I didn't wanna say, no, ask, before I'm wasting time when I. No, they thought you should have. First. What, me?
We'll stand with Paul.
Okay, all right.
I have a minute from surgery.
Yes.
Oh. Yes.
You read with
Joe?
Yeah. Just on this one. You have representatives. This gentleman. back in 2015. Did have what happened.
Mhm.
Then there's some papers.
Mhm.
They don't look that, but so they might have to contact the secretary.
Yes, I don't even remember it.
Yeah.
So it's a 2004 case, but not this case?
No, not this case. It was but yeah, you'd previously represented him.
If she's willing to sign it.
Well, then here's the issue. You want another judge to hear it, then another judge can hear it. I know I represented him in 2004. So,
Long time ago.
yeah. Time flies.
It does.
Yes, yes, I'm up there. Yes, sir.
There's no files.
They can pull the document.
Well,
They have it right here.
They don't have a physical file.
Oh, when I mean file.
Oh, I'm sorry.
I didn't put a piece of anything.
Okay.
They were all there.
I'll have her take it up this, try this out.
I think it was one class. It's one.
You would need to approach her on that. Who's your client? Oh. Oh, go ahead. You can go ahead. She takes all docket matters to be active.
One of the.
Rodolfo,
Okay.
Ask if I can come back to y'all. If she can sign it.
That's fine. Yes. Sisters. You are.
I mean, oh, wait. Does it tell you?
Okay.
You got mine on my calendar. Maybe. Roger. Not on the docket. You don't know. Or the free
Oh,
thing.
here.
Oh,
Who's filing?
okay. I'll send it to you. Oh, okay. Really? Okay. I'm just gonna try to send it.
Yeah, you should just schedule the very.
Okay. No, it's a different case, but so she said she.
Okay.
May I approach Judge?
Yes.
I spoke to Ms. Russell, and I think just because of the prior record.
You know what?
Thank you. I'll follow up with what happened.
And so we'll get it reset by email.
Yes. The other court was for you.
All right. Do you still want me to talk to him when it's in custody?
Yeah, I can talk to you. Like, Robin,
No, I don't.
She's now turned into a.
I guess the time is.
But I don't think y'all have a bottle, right? So I think I when she get back.
We're just waiting for defendants. They're down the bus.
Oh, they're on a bus too.
They're down at the Joe bus.
So something is sabotaged. Something
Yeah,
is sabotaged. Probably beginning of a mission policy.
They're coming, they're walking.
They're walking. Like, there's a chain gang right over down. Going down Common.
Yeah.
In the rain. So, do you have anybody or just?
We have some people that are downstairs.
Do
The
you have
ones that
Barry?
There's downstairs. actually.
Bexar's okay.
Yeah, downstairs.
Can I talk to him?
We're waiting for everything to that. That's
Whenever.
Yeah, we'll be
you're-
sure.
I'm in. If he wants to take the deal, then I can do it. I think it well. Yeah. She says somebody's looking at it first. Like, oh.
Go over there and check in and then want her to repeat that. Tell her to bring whatever evidence she's got about the sleep harassment. Eventually you have to fill an affidavit to the effect of telling her about what's happened. And then we'll hopefully proceed.
So we're not hearing what I just. Correct.
It's already brought up, yeah, bringing them up on this.
I got you. Not to check in my grill and hot.
Yes, I know.
that's what I think.
But I mentioned it,
Oh, yeah. It's even other client meeting. But I have plans. I have plans. I'll figure it out, but she's checking.
yeah, she already checked it.
Go back, like, we'll come in here and
Holding. Hold. Must come.
Nope. Didn't pay attention. That's why you like.
That's what I'm talking about. But you know.
That's you.
She's still I guess he wasn't coming down to me, I know. I mean, I have it, I don't. So. The order, and I remember you pull this thing out. Still do that. It was still like that. Because the office there.
Something intent, right?
We go talk.
So, Deputy Laura, any update on Mr. Rodriguez? Because if he's here, then let's do. And Norman.
This community stuff. He's only 7 years old, baby. I think they were originally.
So.
First, I'm surprised that you're supposed to. Yeah. Supposed to. So. Because we needed him to buy this something. He's got the rule violation going on also. I don't know. Those 2 years are still looking here. Maybe looking at towards those. Okay. I can tell my victim advocate tomorrow, no, sure. I can have her call it, sure. Just to kind of give us an idea of what, save us a lot of work. Right, yeah. I'm trying to find this, it's just from the dad. Okay. Basically. We have to come down there.
I went to go get more information. That's how I've been spent time today.
But guess what? On my bus. I would be with the.
Hey, how's it going?
Doing good. Sorry, I'm dressed this way. I was just gonna.
Sure. They're just, the bus broke down, so we're waiting. Yeah, okay.
I mean, not me, like.
Yeah. So you made it in time.
I don't do, all right.
Adam
I'm
Bazan.
just gonna hang out.
Okay, sure. All right.
BAZAN, yeah.
Judge, are you taking anything up right now for anybody from Idaho?
Yeah, they're out on bond. Hello.
Morning, Judge.
Are you in trial? You're usually in trial somewhere.
Don't jinx me, Judge, not today, not yet. Everybody.
All right, is he here?
I don't.
All right, if you'll come forward. Oh, where is he? Why is he not moving forward?
Maybe that, Judge. Should surprise you, sometimes people are reluctant to walk up here from the audience.
They shouldn't be, I mean, we're friendly. All right, so state on this one, there was some sort of surveillance video.
Judge, I believe discovery hasn't been tendered in the case, but we are doing additional research regarding,
Plea and bar.
yes, so it's my understanding that he may have been cited for this offense.
Okay.
And so I need to reach out to the municipal court and receive the information regarding what they did with that to decide whether I can proceed or not on my case.
All right. Ms. Ferguson, this will be the final discovery date. I need a 30-day reset for discovery.
July 10th.
All right, July 10th. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you.
You're welcome. Thank you.
Application.
That was the.
Yeah. Look straight. From the bottom to the top.
So Mr. Rodriguez isn't here?
They had to do a special run for him.
I mean, did they not know that we're in a jury trial?
Yes.
I don't understand.
Hunt, we had to work something out with Hunt Judge.
Oh, they, you brought, he's one of the people.
On that one, the kid is gonna zoom in. with the ball.
Yield for.
Yeah.
Regular. In your car. I just want to go back from your wall and it says. "These are custom." Yeah, to 2023, it's a he technically.
We had to barter with transport judge. We had to do something to do.
Oh, I feel you.
To make it happen.
I appreciate you.
Yeah.
All right, and Norma, if you can get in touch with Martin Guerra.
Yes.
All right, Roger Mims.
We're ready then.
Hello,
Good morning, Judge.
good morning. So y'all are scheduled for jury trial.
Yes, ma'am.
See y'all back at 1:30.
1:30?
Mhm.
Oh, I'm so sorry. Somebody was asking me another thing.
Amarillo?
Okay.
What's your name?
Mauricio.
That's not him.
Mauricio, how come you follow me around?
Oh.
I was like, I've seen him a lot and that's definitely not him.
I'm so sorry.
You didn't want to get out of the cell, right?
I figured I was in the wrong place.
Everybody wants to come to the 187.
Remember 175?
I'm on
Deputy Lord, if I tell people how awesome you are, they'll move you. So that's why when people ask me how you are, I'm like, she's all right.
All right.
But then I come back and I say, no, she's awesome, because I don't want to block any of your blessings.
He's here now. Oh, so cool. They're gonna be going away. Got it. Oh. Over there. Oh, you can get. Okay.
Vacation from his problem.
Amelia Lopez.
Hi, Judge, how you doing?
Hi, I'm doing okay. How are you doing?
Very good.
I forgot to mention.
That, Yeah, yeah. Yeah.
Are you all ready to proceed?
Yes, Judge.
Oh.
Ready, Your Honor.
All right, just give me one moment. All right, the court is calling. I'm sorry, are you ready?
Oh, yes.
All right, court is calling 2025 CR 0019990. State versus Amelia Lopez. Can I have parties announced for the record?
Rick Pena for the state of Texas.
Larry Bloomquist for the defense.
And are you Amelia Lopez?
Yes, Your Honor.
All right, you entered a plea of guilty on April 15th to the offense of burglary of a habitation. According to your plea bargain agreement, punishment is to be assessed at a cap of 5 silent. There is a $1,500 fine, and there's to be no contact with the complainant. Parties waived PSI. Does anyone have any witnesses?
I do, Your Honor, and I'd like to just make a quick opening and then I'll call some witnesses, Your Honor.
All right, yes.
Judge, I mean, this situation, and we have Emilio Lopez, prior to this event, he was studying to become a firefighter. He was attending college classes to become a firefighter. He's going through a breakup. He has a kind of a bad breakup. He's very emotionally connected to this person. He goes to her house. He wants to talk with her. And then it just gets kind of crazy from the.
And I'm so sorry.
No problem, Judge.
Let me see if the jury's available
Sure thing.
and do this closing argument, and then I'll take your matter up.
Perfect, Judge.
All right, thank you. All right, then we'll see if the jurors are here, and then we could take, they're all here? All right, so if we could take them back and we'll do closing.
Come on, everybody.
They'll bring you right back. And Mr. Blomquist, as soon as they finish with closing arguments, I'll take your matter up.
Rodriguez.
is I'm going to read to you what's called the charge of the court. It's the jury charge. You do not have to memorize it. You will receive the original back with you when I give you leave to begin your deliberations. Members of the jury, the defendant, the defendant, Alexander Rodriguez, stands charged in count 1 of the indictment with the offense of continuous sexual abuse of a young child alleged to have been committed on or about the 11th day of November 2013 through the 11th day of November 2017 in Bexar County, Texas. The defendant, Alexander Rodriguez, stands charged in count 2 of the indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 14th day of November 2014 in Bexar County, Texas. The defendant, Alexander Rodriguez, stands charged in count 3 of the indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 15th day of November 2015 in Bexar County, Texas. To all of these offenses, the defendant has pled not guilty. 1. Our law provides that a person commits the offense of continuous sexual abuse of a young child if during a period that is 30 or more days in duration, the person commits 2 or more acts of sexual abuse, and at the time of the commission of each of the acts of sexual abuse, the actor is 17 years of age or older, and the victim is a child younger than 14 years of age. Just one moment. We have a new court reporter. Here's the copy. Number 2, an act of sexual abuse means any act that is in violation of the penal law prohibiting aggravated sexual assault of a child under section 22.021 of the Texas Penal Code and indecency with a child under section 21.11A1 of the Texas Penal Code if the actor committed the offense in a manner other than by touching, including touching through clothing, the breasts of a child. 3, child means a person younger than 17 years of age. 4, Texas Penal Code Section 22.021 provides that a person commits the offense of aggravated sexual assault of a child if the person intentionally or knowingly causes the penetration of the anus of a child by any means or causes the anus of a child to contact the sexual organ of another person, including the actor, and if the victim is a child younger than 14 years of age at the time of the offense. 5, our law provides that a person commits the offense of indecency with a child by sexual contact if, with a child younger than 17 years of age, the person engages in sexual contact with the child or causes the child to engage in sexual contact. Sexual contact means the following acts if committed with the intent to arouse or gratify the sexual desire of any person. Any touching by a person, including touching through clothing of the breasts of a child, or any touching by a person, including touching through the clothing of any part of the genitals of a child, or any touching of any part of the body of a child, including touching through clothing with any part of the genitals of a person. 6, a person acts intentionally or with intent with respect to the nature of his conduct or to the result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 7, our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The indictment in this case was filed on June 18th, 2024. There's no limitation period for the offenses of continuous sexual abuse of a young child, aggravated sexual assault of a child, and indecency with a child by sexual contact. The phrase on or about means that the state is not required to prove that the alleged offense happened on the exact date alleged. With regards to count one, even though you are not required to agree unanimously on which specific alleged acts of sexual abuse were committed by the defendant or the exact date when those alleged acts were committed, if they were, in order to find the defendant guilty of the offense of continuous sexual abuse of a young child as charged in count one of the indictment, you must agree unanimously that the defendant, during a period that is 30 days or more in duration, committed two or more alleged acts of sexual abuse. With regards to count two, even though the state is not required to prove that the alleged offense happened on the exact date alleged, the jury must be unanimous, which means all 12 of you must agree about the specific instance that is alleged to have occurred, if any, that constituted the offense of indecency with a child by sexual contact as charged in count two of the indictment. With regard to count three, even though the state is not required to prove that the alleged offense happened on the exact date alleged, the jury must be unanimous, which means all 12 of you must agree about the specific instance that is alleged to have occurred, if any, that constituted the offense of indecency with a child by sexual contact as charged in count three of the indictment. 8, count one. Now, if you find from the evidence beyond a reasonable doubt that in Bexar County, Texas, the defendant, Alexander Rodriguez, did then and there during a period that was 30 days or more in duration, to wit, from, on, or about the 11th day of November 2023, If there's any evidence of other acts of misconduct committed by the defendant against the complainant, such evidence, if any, is not to be considered by you unless you believe such acts were committed beyond a reasonable doubt. With regards to those other acts, if any, you are instructed that said evidence was admitted only for the purpose of showing the state of mind of the defendant and the child and the previous and subsequent relationship between the defendant and the child, if it does, and for no other purposes. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statement of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict. But jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you are retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communications relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. All right, ladies and gentlemen, each side will have 20 minutes to present their closing arguments to you. State.
Morning, everyone. I know you will what the judge just read for you, but I want to clarify a few things. Those are specifically about pending charges against it. I'm actually going to begin with count 3. I'm going to work my way to count 1. Okay. Count 3, as the judge read, says if you find some evidence beyond a reasonable doubt that on or about the 5th elements of all of these counts. Okay. You get elements as like a checklist. Okay, you're checking up all your boxes and make sure that everything that you have to get is there. Okay, it's the same for your place. What I just read to you, one about 53 members of the first element, we count 3. Okay? That means was that we have to prove to you, not specifically that it took place in 53 members of the team, but that it occurred during the time period that I think this was between second grade, when she had first period. And 11, 12, somewhere around there, like she testified. That's element 1. She testified to such that. Check that box. Second element in Bexar County, Texas. She testified to several witnesses heard verified this took place at the house on Sugar Road here in San Antonio in Bexar County, Texas. You check that box for element 2. Next, the defendant Alexander Rodriguez. That is element 3. At the beginning of her testimony last week, when we saw her testify, she wrote up and pointed that man right there is the man that did this abuse to her. That box is checked as far as element 3. Next element 3. Did engage in sexual contact with Emily Rodriguez, a child younger than 17 years. She's 17 years old, as she testified to today. This abuse happened between the time she was in second grade and she had her first period. That element is proven. You don't check that box. By touching part of the genitals of Emily Rodriguez. She testified several times throughout these years of abuse, he would touch her vagina. That element is proven. Check that box. With the intent to arouse to gratify the sexual desire of any person. That may be a little bit more complex than the others, but I promise you it's not. Because there is no reason that anybody should touch a child in that way other than to gratify their own sexual desires. That is proven. Check that box. That count has been proven to you all non-reasonable. Go to count 2. Now, if you find from the evidence beyond a reasonable doubt that first element on about the 14th day of November 2014, exact same way as that was proven to you, same count 3, check that box. Fair County, Texas, exactly as it was in count 3, check that box. Abandon Alexander Rodriguez, that element proven the exact same way as it was in count 3, check that box. Engage in sexual contact with child younger than 17 years. 10 years before again, you check that box. New one is by touching the breast of Emily Rodriguez. Again, she testified several times throughout these years of abuse by the defendant, he would touch her breast and nipple area. That is proven to you. You check that box. Last element, with the intent to arouse or gratify a sexual desire. Again, there is no reason why anyone should touch a child in that way other than to gratify their own sexual desires. You check that box, that count is proven to you as well. Now, what's a little bit more complex is count 1, but it really isn't. I'm going to go through it with you again right now. Count 1. Now, if you find from evidence beyond a reasonable doubt that in Bexar County, Texas, the defendant, same way as in counts 2 and 3, you check that box. Did then and there during a period that was 30 days or more in duration, to wit, from on or about the 11th day of November 2013 to the 11th day of November 2017. That's the time frame that the victim testified to you all. From the time she was in 2nd grade up until she had her first period. That element is proven to you. You check that box off. When Alexander Rodriguez was 17 years of age, he's an adult, ladies and gentlemen. He's older than 17. You check that box. Or older, commit 2 or more acts of sexual abuse. I'll get back to you guys on that one. Against Emily Rodriguez, a child younger than 14 years of age. She testified again. This happened from the time she was in 2nd grade until she had her first period, well before the age of 14. That is proven to you. You check that box. So let's get back to that element previous. Commit 2 or more acts of sexual abuse. And you all have 3 ways to decide how those 2 acts are proven. Number 1, Alexander Rodriguez did intentionally or knowingly cause the sexual organ of Alexander Rodriguez to penetrate the anus of Emily Rodriguez, a child who was younger than 14 years of age. This is her testifying to you all that he would use his penis to penetrate her anus. Okay. Number 2, Alexander Rodriguez did intentionally or knowingly cause the sexual organ of Alexander Rodriguez to contact the anus of Emily Rodriguez, a child who was younger than 14 years of age. This is her testifying to you all as well about him touching her anus with his penis. The third one, Alexander Rodriguez did intentionally or knowingly engage in sexual contact with Emily Rodriguez, a child younger than 14 years of age, by causing Emily Rodriguez to touch part of the genitals of Alexander Rodriguez with the intent to arouse or gratify the sexual desire of any person. That is her testimony, that at night in bed, he would pull down her underwear, take his pants off, grab her hand, put it on his penis, put his hand on top of her hand, and use it to masturbate. Those are the 3 options you have. You all do not have to agree on those 3. You, sir, could think that he penetrated her anus with his penis and touched her anus with his penis. You, sir, could think that he touched her anus with his penis and he masturbated himself with her hand. You could think that he touched her anus with his penis and he penetrated her anus, and the third one as well. You could think that masturbate both times. You could think touch anus both times. You could think penetrate anus both times. It doesn't matter. So long as you all agree on at least 2 of those, that is proven. All 3 of those have actually been proven to you, and you should find him guilty on count 1, 2, and 3. This man is supposed to be her father, her greatest protector, but unfortunately he has become the man of her nightmares. I think we'll reserve the rest of its time. Thank you.
Defense.
Morning, ladies and gentlemen of the jury. Good morning. It's been a long 2 weeks. I'll try and be as brief as possible, but we have a lot to get through. This is not a grocery checklist. This is not a task list. This is not a quiz. This is his life. And it's serious. This is the rest of his life. So we should treat it as such. We are going to ask that you find him not guilty on all counts. Can you play? Let's talk about what you did here. The investigation or lack thereof. Deputy Jaime, he never spoke to Emily. Child outcries September 15th of 2022. He goes to the home and talks to Clarissa. Where the hell is Emily? Your child just outcried of sexual abuse for the last 5 years? Why wasn't she home? Where was she? Clarissa didn't disclose the affair to that officer because of Roy. The only thing that deputy testified was that a crime may have occurred. That was his only task, to take contact information, address information from my client so that the police had that information. My clients lived there for as long as anyone can even remember. Let's talk about Detective Trevino. If anyone needs to change careers, it's Detective Trevino. He never went to the home. He never collected not one piece of evidence. Reminder, all the exhibits that you got, 40 plus exhibits, not one from the state. Not one. They never talked to the school counselor. That's huge. This was the first adult she told about what allegedly happened. And mind you, when Emily came back and testified, she said the only reason she said something was because the counselor went to go find her. He never talked to Emily. He testified to that. Never talked to Emily. And you know why that's really important? Because Emily got on that stand and was able to be manipulated and malleable to be able to say, oh yeah, I talked to him. She did. They implanted these memories onto her, or she just straight up lied, just to be agreeable. That's terrible. That is absolutely terrible. He never reviewed the body camera footage. It just wasn't important for him. He's about to send this man to prison for the rest of his life, and he can't be bothered to review a video. He never even reviewed his own interview with Clarissa to look for inconsistencies. He never talked to the reporting officer to look for inconsistencies. He never requested CPS records. Guess who did? I did. We did. He never requested therapy notes. Guess who did? We did. He never requested medical records. Guess who did? We did. He never got school records. Guess who did? We did. He never talked to friends, family. He never talked to the teachers or principals. Some of you in here, I think, are teachers. You know which students make up big lies and which ones don't. That's huge. They know the goings on at school. They know if someone's a known liar. They know who's telling the truth and who's lying and who makes stuff up. But he couldn't be bothered to do that. They never talked to neighbors who could have heard something going on, seen something going on. Never talked to the principal. Hey, does Emily have any behavioral issues? Does she have problems with authority? Didn't matter. Doesn't matter. Never spoke to Alex's family. That is huge. These are the people that were living in the same household where this alleged abuse was going on. Why not reach out to them? He never spoke to any other potential suspects, which includes the people in the home. You know what I find very interesting? State never asked any of the witnesses, did you touch him? Did you touch Emily? Such a simple question, right? Never asked. They teach you in law school, never ask questions that you don't know the answer to. There was no eyewitnesses, no DNA, no SANE exam, and he testified, yeah, victims sometimes lie. He never collected Emily's cell phone. When Emily testified, she said, yeah, we had a really good relationship. She recognized her dad's cell phone from years ago. That's his cell phone. And yeah, we called each other bra, we called each other shorty. We had a great relationship. I wanted to spend more time with him. That is absurd. That is absolutely absurd. Someone has anally raped you for 5 years, every single visit, and you want to spend more time. Doesn't make sense. He never collected Clarissa's cell phone. If he had, he would have found thousands and thousands of sexually explicit material from Clarissa sent to Alex during the middle of her marriage. He never looked for custody orders. You saw the petition that was introduced. It was there. He just took Clarissa's word for it that there was no paperwork on it. Let's talk about Clarissa. She asked Emily to keep secrets for her benefit so that she could continue this affair over the course of 4 to 5 years. She testified she couldn't remember her weekly sexual visits with Alex. You heard from multiple members of the household she'd come by every week for their rendezvous, with or without Emily. However, she also testified she would send sexually explicit photographs to him. However, she could not remember the purling. That doesn't make any sense. She didn't say, I'm not denying that he has those purling. I just don't remember. That doesn't make sense. You know that. I know that. Everyone here knows that. She testified they had the affair from 2014 to 2017. She also testified, yeah, I asked for money. Your daughter has alleged she was anally penetrated for years, and you don't care. I'll take your money. You still owe me. Give me the money. Even after he was arrested, she's still asking for money. She would send Alex updates about how she's doing. Oh, she's doing great in the orchestra. What? She goes to this school now. This is a man who raped your child, and I'm going to give you an update as to how she's doing. She misses you. She's wonderful. She's doing really great in school. That doesn't make any sense. She didn't believe that she was actually raped. It doesn't make sense. She told Alex about the abuse that she was suffering at the hands of Roy, her husband. Not just Emily, but the other kids as well. Thousands of sexual communications between the two. Thousands. And she claims that her mom faked those 2 CPS challenges and requested monthly rape kits for Emily. This was before the outcry. This was before the outcry. Someone asked for monthly rape kits of Emily. And Clarissa says it was probably my mom. She's crazy. Well, the apple doesn't fall far from the tree. Eric Mata. He denied that Emily ever mentioned camping. It happened on the same day, on the same days, same time, same place. Nothing about camping. Then when she testified in front of you the first time, she didn't mention camping. Then when we brought her back, oh yeah, it happened when we were camping and there was other family around and there was other campgoers, but he still did those things to me. It doesn't make any sense. It does not make sense. Eric said that she yelped at the pain of penetration. I don't know what the answer is here. She testified in front of you that there was no penetration. She wasn't sure. How can you convict somebody who doesn't even know if something happened or not? How can you put him in prison if you don't know? He never asked if she was sexually active or knew what a penis looked like. He never asked if she was forced to be in the room telling her story. He says that that Alex tried to kiss her. She never told you guys that. She never told the DA's office that. She never told CPS that. She never told the counselor that. She never told her mom that. Emily didn't mention showering afterwards. Imagine a 6-year-old child who's been anally penetrated for years, getting up, taking a shower, and staying in the bathroom for hours. Never mentioned that. Not to him. Roy Herrera, where is he? He was subpoenaed. Clarissa confirmed he was subpoenaed for us. We wanted to hear from him. We wanted to see what kind of influence he had over Emily, but he was stubborn and didn't want to be questioned. School counselor, where is she? She was the first adult that talked to her. Where is she? The timeline. We know the pearling procedure happened in 2011. 2014, Alex moves in with his mother and the visits start happening. Alex, Christina, and Ethan are living together. She was 7. Then in 2015, Alex and Clarissa begin their affair. Again, Alex, Christina, Ethan are all living together. Then 2016, the affair continues. Alex, Clarissa, Ethan are living together. Emily is 9. 2017, I put down here, Emily gets her period. Who knows? She has no idea whether it's 2017, 2018, 2019, but somewhere in there, she's living with Alex, John Paul, and Ethan. And we know the affair keeps happening because John Paul and Ethan both testified Clarissa's coming by weekly. 2020, Alex and Clarissa end their relationship and things spiral. He meets Lisette and starts dating her, and he's still living with Alex, John Paul, and Ethan. This was when Emily's 13. 2021, Clarissa starts asking for money. They're not dating anymore, so she wants her money. She's not getting those dates anymore. She wants her money. Lisette moves in with the kids. Emily allegedly commits or tries to commit suicide. Alex, Lisette, and the kids all move in together. And she doesn't want to share a room. She doesn't want to be there. She is starting to pull away. 2022, Emily starts sneaking out, and somebody files and asks for monthly rape kits of Emily with CPS. Then 3 months later, here comes the outcry. Alex, Lisette, and the kids. CPS interviews the kids. No outcries. No outcries of abuse. And they leave the kids with Alex, little kids. No one believes this. After the outcry, guess who's still messaging Lisette and Alex? Emily. She misses them. She wants to talk to them. She wants to see how they're doing. She gives them updates about herself and her mother. And what I find the strangest about all of this, Clarissa moves to Houston with Roy and the other kids and leaves Emily. Who does that? You have a man who is her father, who has legal custody of her, right? And you move to another city without her, without any protection whatsoever. He hasn't been arrested at that point. How protective is she as a mother? She knew this isn't true. She knows this was not true. Again, Alex, Lisette, and the kids continue to be together. In 2023, in January of 2023, the detective turns the case into the district attorney's office.
5 minutes.
Thank you, Judge. Clarissa continues in 2024 to message Lisette and Alex. Alex is arrested. Then Emily's still going on vacation with his family. None of that makes any sense. None of it. And guess who's still asking for money? Clarissa. We talked about when is it too late to walk a lie back. Emily stated, I asked, do you think you're going to get in trouble if you say you made all of this up? And she says yes. Winston Churchill said, a lie gets halfway around the world before the truth has a chance to put on his pants. The DA's office sat on this case for 1.5 years. That disadvantages us.
Proper argument, Judge.
Sustained.
Common sense. They have the burden of proof. You can find somebody guilty based on the testimony of one witness, but that one witness has to be credible, and Emily is not credible. Remember the standard of proof. They have to prove every element beyond a reasonable doubt. And remember, to terminate your rights as a parent, it has to be clear and convincing. If it's not enough to terminate your rights as a parent, which obviously it wasn't for his rights were never terminated, then it's not enough evidence to take his freedom for the rest of his life. The inconsistencies. Emily said it was every other weekend in the same room, same time and place. And then years later, she says, oh, actually, we were camping. She claimed she felt something wet on her back, and then later claimed she actually smelled it and tasted it. Then she said the abuse started at 5, maybe 6, maybe 7. It stopped when I was 10, maybe 11, maybe 12. She claimed she was anally penetrated, then changed her mind and said, no, actually, I don't think it was. I think it was only contact, but no penetration. But we know there was no signs of penetration. We know there was no staining, there were no tears, no blood. No emotional changes at the time of the alleged abuse. Nobody knew anything was happening. She said she was pretending to be asleep. So she had her eyes open and closed. She told CPS she was asked specifically by CPS during this time, is anyone touching you? No. She was asked by her mom, is anyone touching you? No. She told his mother, Alex's mother, she felt guilty and that she still does to this day. You do not feel guilty about something unless you've done something wrong. She never mentioned the beads. It's reasonable doubt. There's no physical evidence. There's no eyewitnesses. There's no signs of abuse. Clarissa has a motive to lie. She manipulated Emily. Emily's testimony is unreliable. Look at these messages. Is this someone who has been sexually abused? I want to see more of you. You're the best dad in the world. Nobody forced her to do that. Nobody forced her to do that. Read those messages. If at the thought that you had when the state rested their case, is that it? Is that all it takes for you to be charged with a crime? Is the word of an emotionally disturbed child? That is pretty scary because any one of you could be in this situation. There's no evidence against Alex. The defense put on 40 plus exhibits and the state put on 0. Not guilty does not mean you don't believe something happened. Not guilty doesn't mean I think Emily is lying about everything. It doesn't mean that Alex is a saint or that he's going to even get custody. It does mean that the state didn't prove each and every one of their elements beyond a reasonable doubt. It does mean that you upheld your oath. You swore and you took an oath to follow the law. And if you have doubts, and I know you do, then your vote should be not guilty on all counts. If you go back to the jury room and you think to yourself, I don't know who's telling the truth or who's lying. I don't know what happened. Then it's simple, not guilty. I want you to look at the verdict form in the back. Not guilty is up the top on each count of 3 counts. You choose a presiding juror, they sign at the top, and we end this ridiculous trial and nightmare for Alex.
Time.
Thank you very much.
State's at 13 minutes, 11 seconds.
Thank you, Judge.
I felt guilty. I felt guilty. I wish I had talked to him about it. I felt scared. I thought you were afraid of him. I was. Parts of him. There were good parts of him too. I felt guilty. Like I was ruining his life, like it was my fault. Members of the jury, you never want to hear a child say what Emily said. You don't want to hear it because you know it's true. You know that even after everything her father has done to her, she loves him. Even after all the years of molestation and sexual abuse, she loves him. Even after getting called a liar, she loves him. And I'll bookend that with the testimony of the very last person you heard from the defense, Deanna. Defense asked if Emily was malleable, right? That was the defense's word, malleable. And Deanna said, I wouldn't say malleable. And Deanna noted 2 things after that. She said that Emily was concerned with hurting someone else's feelings. And she said that Emily will feel really bad if she thinks she's hurt your feelings. Did you hear that in the trial? You bet you did. Repeatedly, I felt guilty, like it was my fault. And she couldn't even raise her voice on the stand. The same kid that would go to an HEB, remember the testimony of Ethan, and stand zoned out at the milk, right? That's the same kid you saw on the stand. In fact, in line with not raising her voice, this is a kid that didn't feel like she had a voice. She didn't have a voice, so she tried to kill herself. And notice during the defense's cross-examination, there was a lot of discussion, right, on the exact day that she attempted suicide, right? The exact day. Was it the same day that you talked to the counselor? No, not the same day. You told ChildSafe it was the same day. No, I don't remember saying that. Not the same day. I never told someone it was the same day. I didn't try to kill myself that day. Members of the jury, that's the when. The when, right? So in the who, what, when, where, why analysis, we all agree on the who, the what, the where, the why, and we really almost agree to the exact day on the when. You know what that tells you with respect to the attempted suicide? That it happened. But go with me here. With respect to the attempted suicide, the whole time she's talking about that, I think the parallels became very clear and twofold. One, the lack of specificity with the date as it relates to both her attempted suicide and her first period. Okay? This is a girl that struggles with the exactitude of dates. This is not a girl that struggles with the clarity of the memorability of those events. You know what is clear? She attempted suicide. You know what else is clear? That when she got her first period, her father stopped sexually abusing her. Those were clear. And the second parallel between those 2 events, right, is that the defense had to, again, attack the minutia or specificity in order to detract from the truth, right? Defense, so it was every weekend? No, almost. So it was all the time? No, almost. Emily said he would say my name or talk to me. He would check to see if I was awake. You never told anyone he would assault you during the alleged assault. No, not during. Beforehand, sometimes afterward, to see if I was awake. And I'm not splitting hairs. I am not splitting hairs. Almost every weekend is not every weekend. Talking to your daughter before or after is not talking to her literally while you're in the act of assaulting her. Those are 2 different things. And she was clear on that from start to finish. Now we're going to dive into the defense counsel arguments here. But first, remember in voir dire when I discussed the rules of football? You remember that? I did that because I knew I'd be spending the majority of my time in this trial objecting. I know how they argue. You saw that. You remember during voir dire 2 when I was talking about the Sabrina Carpenter, the coffee example with jury number 52? I knew they would spend a majority of their time in this trial trying to muddy the waters, even with the non-victim witnesses. right? So remember Eric Mata, remember the forensic interviewer? He got on the stand. What about the camping trips? What about the mother? What about the affair? I don't know. We never discussed that. I don't recall. You don't know? You never discussed that? You don't recall? Finally, Eric, a grown man, you watched it. He put his hands up and said, I'm sorry, I'm not trying to be disrespectful. I don't know what you're talking about. That's what he said. Does that remind you of anything? It's coffee. It's coffee. It's coffee. It's almost like I knew what they were going to do. That's how they argue. Now, some of these defense counsel arguments, you just heard counsel talk about the fact that Emily didn't tell her mother everything. They just said that. She doesn't know the full extent. She's learning the full extent right here, right now. With respect to Eric Mata, he was able to testify as to the things he heard because the victim specified with clarity the things that happened. That's why I was able to ask him on the stand, what did she say? What did she tell you? Right? The law provides that opportunity for him specifically because he can testify as to the specificity that she relayed. I didn't have that opportunity with other witnesses. I had it with him. That's the opportunity that the law provides me. So yeah, counsel talks about the 42 exhibits, whatever number. Yeah, look at those pictures of SeaWorld. Okay, look at the pictures of the theme park. What do you expect this kid to do for 4 years? Hide under a blanket? Is that what you want? What do you expect? We talked about in voir dire how kids react differently. We talked about it for that exact reason. It's always the photo of SeaWorld. Oh, and she would text him and write him Father's Day cards. Again, what did you expect? That's why we didn't even object to those coming in. The photos themselves are a disgusting enough notion. We talked about that, right? I went through it. Daylight, people there. I did all that in cross-examination. We already talked about that. But the letters, does that not make perfect sense for a kid that loves her father? A kid that doesn't want to hurt anyone's feelings? In fact, this is actually somebody, she has no problem hurting herself, right? But it's others that she cares about. What was she supposed to do? So if she's a good student, well, nobody ever noticed any issues, so she must be lying about sexual assault. She had bad grades? Well, you had bad grades, so you were mad at your father about something, so you made up sexual assault. Either way, that's how they're going to paint it. Other people lived in the home with paper-thin walls. It's always the paper-thin walls, right? So thin you could hear someone put their socks on. I asked that ridiculous question. He backed off on it. But that's my first question was, so thin you could hear someone put their socks on? I mean, yeah. So someone that said they wouldn't lie for the family, but you can hear socks being put on in another room? Okay, that's incredible. That's incredible testimony. Another defensive argument was the lack of DNA or physical evidence. This was a years-long delayed outcry. Years, right? This is what we talked about in voir dire. This is why Detective Trevino said repeatedly, you're not going to get evidence after 120 hours. This wasn't a 120-hour delayed outcry. It wasn't 120 days, right? It wasn't 120 weeks. This was years and years and years. Until finally, she told the person that she thought couldn't say anything. Remember when she testified? She only told the counselor because she was under the impression that that person couldn't say anything. Does that sound consistent? Like someone that doesn't want to hurt someone's feelings? The girl that somehow still loves her father, that raped and molested her, the girl that doesn't have a motive to lie. Let's get into motive. She didn't have a motive back then, right? There's no nasty divorce with the $1 million home, right? There's no real custody issues at all. Plenty of testimony after the period. He took her there. That's all contextual. There's really there's no haranguing. There's no mistake, no problems, no divorce, no custody issues. Things just kind of seem to be a handshake agreement.
5 minutes.
Really no problems. Now, the defense can posture that Emily was receiving pressure from her mother, but Deanna Wood, their own witness, said again that her impression of Emily was that she was not malleable. She went on to say that she herself did not see any pressure or power of the mother over Emily. That's their witness. Eric Mata noted that she didn't appear to be under any external pressure or influence. And then he provided the additional context. They child safe, they screened for coaching too. That's what forensics do. That's what he's done for over 2,500 forensic interviews. This is what he does. If she had a motive to lie, then just say his penis went inside you. You're almost all the way there. You yelped and felt pain. I'm telling you, if you have a motive to lie, just go all the way. Why stop there? Why? And if you really have a motive to lie, Just say it happened every single time you went over there. My God, wouldn't that be easier? Not almost, not correcting almost every time. Every time, almost. If you're really gonna lie, God, just make it simple. Make it a binary. Every time I went over there, I was raped. Every time? Yeah, every time. Yep, every time. Simple, every time. If you have a motive to lie, that's what you do. And if you have a motive to lie, just say you were facing him. Don't speak to the truth of the fact that he would whisper behind you. He's the only one that ever went into the room. You knew it was him. Just lie and say, yep, looked right in his eyes every single time he molested me. If you have a motive to lie, just do it. Just take it all the way. Why are you stopping there? She doesn't have a motive to lie. There is no motive to lie. The mom's pressure over her, for what? To what end? What are we doing here? There is no motive to lie. She didn't back then. She doesn't now. She didn't not once. And I got her words on her words myself, right? Remember when they called her back up again, I drew the timeline on the board right here, right? I put the X second grade to the time that the period happened. And I wasn't sitting in between the tables, right? Remember the first time I sat between the tables, I'm asking her questions. What happened? Tell me about this. I stood literally where I'm sitting there. I put a marker in her face and I say, don't just tell me what I want to hear. Second grade? Was it first grade? Was it third grade? It was second. Okay, well, did it happen when the abuse stop when your period happened? Were you 10, 11, 12? Don't just tell me what I want to hear. I've never spoken to a child witness that way. Don't just tell me what you think I want to hear. I almost yelled it at her. You guys, I was standing right there. But I had to do that. I had to yell at her. I had to put the marker in her face. I had to draw the line. I had to say all those things because when you go back there, I want you to know that she's the same quiet girl. She's consistent, even when it's me that's yelling at her. And she was the same girl without a motive to lie. We have the sensory details about wet and hairy. Eric Mata told you about the importance of those details. But then you go to the consistency and cooperation across the accounts. And I kind of drew that grid yesterday, right? You have what she told CPS. You had what she told the forensic interviewer. You had what she told the DA's office. We have the testimony where Detective Trevino, right? He's the 30,000-foot guy, sees everything. Clarity and consistency across all the accounts. There's actually some testimony about the therapist. It was very brief, but the therapist in his discussion with the detective, where he said she was consistent in her outcry, even with the therapist years later. She got on the stand Thursday. She got on the stand yesterday. So that's 7 different accounts across multiple years, across multiple people, and it's the same story every single time. It's the same account. It's the same retelling. It's the same details. It's the same person. With respect to count 1, continuous sexual abuse of a young child, you're going to see it right here, like Rick pointed out to you. You're going to see count 2, indecency with a child by contact. And you're going to see count 3, indecency with a child by contact. Given everything we've talked about, her true motive to lie, the fact that she was clear and consistent across those 7 accounts, across all those temporal dimensions, across all those time periods, across all those people, we're going to respectfully request a verdict of guilty. Thank you.
All right, ladies and gentlemen, you've heard all the evidence in this case, and Deputy Laura will take you to the back.
Okay, well, I can't, that's why I'm trying to decipher this, that's why.
This was
I'm
admitted.
just.
7 through 22.
Pictures.
So I think like what's in your hand? This shall confirm 7/3/20.
Cannot be, can he just put it back in the holding cell?
Oh, they may need to speak to him like 2 seconds.
Yeah. Let's bring them all out.
All right, thank you.
18, 19. 22.
Yep,
Okay,
that was
They were
very good.
admitted.
And
Okay,
then you have 23 and 24.
23.
You're done. Then you have 32.
That's 32.
What was it? Oh.
Then you have 33.
Which is what is the?
It's like a photo.
Another photo.
They're on the back, because I marked some. and she
Oh, here,
marked some, yeah.
33, okay,
34,
34,
Yeah, it
35,
could be all those.
okay,
36.
okay,
38,
no, 37?
37,
Okay.
38.
Huh?
And then I've got.
He said 38. He didn't say 39. You didn't say 39?
Not 39,
Okay. Uh-huh,
41.
okay,
And then-
That's,
That's it?
yeah.
that's it, okay, so, okay,
The rest didn't get admitted.
nothing else. Okay, so there's no 1 through 6.
This was demonstrative.
Oh.
No.
You have what?
Remember honest thing? I'll get on the.
Yeah, probably the deputy.
Okay.
Okay, Judge,
Yes.
I went over the evidence with both count sides.
All right, thank you. Wait a minute, let me see,
I didn't see it. You would have to reach it out.
attorneys, you all need to clear the center of the well. Thank you.
I got people coming behind you. And my walkway is clear.
And then Mr. Bloomquist, as soon as the court reporter comes back, we'll take your matter out.
Problem, Judge.
Absolutely. You absolutely.
Who's here on Anthony Villarreal?
Charles Gold, Your Honor.
Yes, that's at 1:30.
Where's the file? He's, right, yeah, I thought we were here this morning, Judge, I'm sorry. Right, yeah. Yes, and also I have a ALR at 1 and a dentist appointment at 2:30.
Oh, that's just what they're doing. That's not. In ranking, this is first. Have your client come up.
Ellie's here, my daughter. You saw the closing right there? That's cool. Choose. My 16-year-old's here.
Oh.
Well,
wait. Then we need to meet her.
Show up.
Okay, of course, sir.
You didn't listen? She may still have it.
All
I
right.
don't know.
So, you all are saying this case is going to resolve itself?
It may. It's.
I gave him some new
They gave
information.
New information yesterday. And, it's something that I feel that I need to probably get to the end of it.
All right. So when is this gonna happen?
next 30 days.
All right, so this is what I'm gonna tell everybody. I'm setting it for disposition. If it's not worked out on this date, you all are going to jury trial. All right, Ms. Ferguson, I need a 30-day reset.
Yes, ma'am. I'll do July 10th. Judge.
All right, July 10th.
Let me double check. It should be a good judge. If
Oh,
I.
it's good.
We get to Cleo. July the 10th.
Oh, it's a beautiful day. All right, thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Thank you.
All right, thank you.
Yeah, I'm wide open that day. You want to meet, Miss Ellie?
Yes.
Miss. You got all dressed up for you today, Judge.
Hi. Are you, you too? You know what, you should have argued your dad's motion. That would have come off better.
I think so, probably so. A lot sweeter for sure.
So what are your plans? Are you just hanging around him?
I want to shadow him so I can see what it's like. I want to go to law school and be a lawyer like him.
Oh,
Yeah.
so great. Is he paying you today?
Lunch.
For just,
No.
court log hours.
He should be paid. Excuse me. I need an employment attorney. The father is working his daughter without paying her.
Right.
Hey, you gotta give her a good meal. If he doesn't give you a good meal, let me know.
Yes, ma'am.
But you're welcome anytime. And if you want to, the jury's out deliberating right now. But if he were to be found guilty, they're deciding to come to me for punishment. So there's no punishment phase by the jury if they were to find him guilty. And then after this, we have a sentencing case with Mr. Bloomquist.
Sit watch us. Yeah, you'd like this. Yeah.
Yeah, so
You like-
anytime.
So you decide the punishment.
Yes, if they were to find him guilty. And then this case, there was a plea agreement, so then I decide punishment on that as well. They have witnesses to present to the court.
Interesting.
And then-
Oh my gosh, that's.
Yeah.
Oh, you look great.
Thank you, Judge.
Sure, thank you. Have a good day.
It's nice to meet you.
You too.
Hi.
All right, Mr. Bloomquist,
Yeah.
are you ready?
Yes.
And do we, I can't see over my thing.
Anthony Villarreal. Slide.
Bill, make sure you speak loud enough for the court reporter to hear you.
We're back on the record in 2025 CR 001990, State versus Emilio Lopez. And can I have parties reannounce?
Rick Pena for the state of Texas.
Larry Bloomquist for the defense.
All right, and Mr. Bloomquist, you have begun your
Yeah.
opening for the court.
Yes, Judge. I just want to clarify for the court. So my client was in a relationship with the victim. They had been in a lot of a dating relationship. That relationship had gone south. My client was very distraught about that. He went to her home to talk with her. I believe the evidence could show he didn't have any intent to commit any act of violence against her during that. She opens the door. She's very upset to see him. She starts to yell. Things get out of control. He does push his way into her apartment and does commit burglary. At some point, she's yelling and he falls on top of her. It's a really regrettable situation. I think the evidence is going to show that Mr. Lopez is taking full responsibility for the actions that he did that day. I believe he understands that what he did was wrong, and then also think the evidence is going to show that this is out of character for Mr. Lopez. And now I'll just call my first witness.
All right,
Can I call Emily Lopez?
all right, you'll need to step that way.
She's just on like that. Yes,
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth to help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Emily Lopez.
All right, make sure you keep your voice up so that I can hear.
Okay.
All right, defense, you may proceed.
And how are you related to Emilio Lopez?
He's my little brother.
Okay. And what's the age difference between the two of you?
3 years.
And is he the youngest child in your family?
Yes, sir.
And how many other siblings do you have?
One older brother.
And where did you grow up? Okay, what kind of kid was Emilio as you were growing up?
He was a lot. He was very active, very fun. He was very well liked by his friends and our family. Like, we have younger siblings, we all love him a lot.
I think you told me that he was kind of a quiet kid, but all the kids in school liked him. Can you describe that for the court?
Yeah, so he's very active at home. In school, he was more on the quiet side. But even then, even like that, the other students would always follow him around and his opinion, and just like the teachers would kind of use him to guide other students in a way.
Okay.
Mhm.
And then your mom did she have epilepsy?
She gets seizures.
Okay, so she would have seizures.
Mhm.
Tell me about how Amelia would react when your mom had seizures.
Well, the first time it happened, he was by himself. He took care of her on his own. But then after that, there was me and my siblings there, but he was a lot calmer, and so he was able to help guide me and my older brother on what to do to help her in the situation and to make sure everybody was safe.
Okay. And that was something that he kind of did whenever she would have a seizure. He would kind of step forward,
Mhm.
even though he was the youngest.
Yes.
The last couple years, so what city do you reside in?
Bryan, Texas.
And at some point, did Emilio come to live with you in Bryan?
Yes, 2 years ago.
Okay. And so when he came there to what was he doing in Bryan?
He was working and trying to get college hours so he could apply to be a firefighter.
Okay. And when he was going through this program to become a firefighter, are you aware that that's no longer an option for him now because of the felony charge, felony arrest and all that?
Yes, sir.
Okay. And then, was that something he really cared about, was trying to become a firefighter?
Yes, sir.
As far as work, where's he been working since he's been there in Bryan College Station?
He worked at Lay's Pizza. He was a shift lead there, I think.
Mhm.
And then he was also a shift lead at a barbecue place.
Okay. And is it true that he won employee of the month multiple months during the time he was working there?
Yes, sir.
During the time that Amelia was going through this breakup, did you notice a change in his behavior?
Yeah, he was a lot more, I don't know, like reserved. He spent a lot of time in his room, didn't really interact with us that much anymore.
Okay.
Can you keep your voice up, please?
And was he really hurt when the relationship ended?
Yes, sir.
And is there anything you want the judge to know before she decides the sentence of Amelia?
We just care about him a lot, so, and I recognize he made a mistake or he has owned up to it.
And that's something he's been doing throughout this process is taking responsibility for what he did.
Yes, sir.
And has he expressed to you that he's upset about how his actions have affected the rest of the people in the family?
Mhm. Yes, sir.
And how has he done that?
Well, he's told me outright that he knows that he shouldn't have done that. He shouldn't have put her in that situation, but also he recognizes that we've been affected by it as well.
Okay. And if the judge were to grant Emilio probation, do you have any doubt that he would do everything he could to be successful in doing that? I'll pass witness.
Any questions?
Just a few questions now. I couldn't hear a little bit at the beginning, but you said he's your little brother?
Yes,
And how far apart are you guys in age?
3 years.
3 years, okay. You're aware that he was in a relationship with the victim in the case? Do you know how long they were dating?
Probably a year and a half.
Do you know if this was his first relationship ever with the girl?
Yes.
First one, okay. Do you feel that men who do what he did to a woman should be properly punished? No further questions, Ron.
All right, thank you so much.
We'll call.
All right, before you call your next witness, because I like to get to the point. This is my understanding. You can come back. This is my understanding of the facts of this case. How old are you? 22. And at the time this happened in 2024, you're maybe 21.
Yes, sir.
All right. So what I'm hearing is that you were in a relationship with someone. Your sister testified that this is the first relationship he's ever heard. Does anyone doubt that this was his first relationship?
At this point, I don't have any doubts about that.
All right. So he's in a relationship with somebody for a year. And if my reading of the facts are incorrect, let me know. He's in a relationship with her for a year. They end up breaking up. According to police reports, they're either breaking up by text or phone. And then sometimes they would get back together, then break up again and get back together. He's in College Station. He finds out that during the relationship that maybe he wasn't the only person she was dating. I'll put it that way. So for some reason, this 21-year-old drives all the way from College Station to San Antonio. How long a drive is that?
About 3.5, 4 hours, Your Honor.
3 and 4 hours to talk to her about the breakup of their relationship, and he wants to get back together. So he comes back to the apartment. In the apartment is the complainant he was dating, the complainant's sister, and the sister's boyfriend. Now, they say that he knocks on the door or whatever. No, he enters the door with a key because he had made a copy of the key, which she didn't know he had made a copy of the key during their relationship. She sees him opening the door or whatever. He ends up entering the habitation, which anytime you enter a habitation without permission, any parts of your body or whatever, that becomes the burglary. And then he is talking to her, pushing her back to the room, want to talk about the breakup of the relationship or the facts that she maybe was untrue to him. They go into her bedroom. He's pushing her towards the bedroom. Police report, he wants to talk to her. In the report, she says that he has a pocket knife. The officer says, he questions him. He says, yes, I do own a pocket knife, but I never displayed a pocket knife. He never left the apartment. The police don't find a pocket knife in the apartment or a pocket knife on him. Is that correct?
Yes, I believe
To an
so.
yes, but there's.
But I mean, there's no pocket knife ever found. Did somebody find a pocket knife?
As an officer of the court, I can say I've spoken to the victim and her sister, and a pocket knife was found by them underneath the victim's bed in her bedroom.
All right, did somebody call the police and say, hey, you didn't do a proper search, there's a pocket knife underneath the bed?
I believe they did that after the fact, no.
All right, so
And let
according
me
to
just add one thing to that, Judge. When he's asked, I think the police officer asked him while because after the event, he sits on the stoop and waits for the police to be called. And then when the police officer comes, I think he told him that he had the pocket knife always, that he uses it for his job, but he didn't use it in any way.
Oh, no, I mean, I'm just going by
Yes,
what
sir.
the police
Yes, Your
report
Honor.
says. Police report says suspect, that's you, stated he did have a pocket knife on his person, but never displayed or brandished the weapon to the victim or other persons in the apartment. It should be documented that the pocket knife was not found on his person or inside the apartment. So now let's get to the point. State is silent, which means they want me to determine whether or not he should go to prison or whether or not he should be placed on deferred adjudication. Does the complainant want him in prison? Does anybody know?
She's right here, Your Honor.
You want to ask her?
Can go ask.
And this is just something for me to consider. It's not saying I'll send him to prison. It's just for me to
No,
consider.
I understand, Judge.
Yeah.
I mean, that's a reasonable.
Victim would like prison.
All right. All right, I'll hear the remaining of your witnesses.
Okay, Your Honor, I call Emilio Lopez Senior.
All right. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth or nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up because I have to hear and the court reporter has to hear. All right, if you'll state your name for the record.
Emilio Lopez.
All right, defense, you may proceed.
And how are you related to this other young Emilio Lopez?
It's a good son and trying to make a good life.
Okay. And where did Emilio grow up? What city did he grow up in?
Broadview.
Okay. And then prior to and what kind of child was he?
So just a second.
Yeah.
So it would help if you don't turn
Yeah.
towards the defense
Oh.
counsel because you're turning your back
Yeah.
to the court reporter.
Yeah.
All right, if you all want to speak closer to the court reporter, you can. I
Yeah.
can hear you from over here.
Okay.
So.
Yeah, just keep your voice up because there's always just when you have 20 people in a room, there's always some shuffling. What kind of child was he growing up?
Good son and trying to get a good life.
Has Emilio ever been in trouble before? Has he ever been arrested for any crime prior to this?
No.
Has Emilio consistently throughout his young life, has he consistently worked at different jobs?
Yes, and Broadview and then in Bryan, Texas.
Okay. And if he is granted probation, would he have a place to stay there with you in either Brownsville?
Yes, in my house.
Okay. And would you also do you believe that he would follow all rules that the court gave him and do everything he could if he was given orders by the court to follow those orders?
Yes, gonna do it.
Okay. Has Emilio in his entire life, has he ever shown any acts of violence or any time has he been a violent person?
No, no.
Is there anything you'd like to tell the judge prior to you entering the sentence in this case?
Well, perhaps sorry, he made a mistake and he's gonna try to be a good boy and good son, like every time.
I'll pass witness at this time.
Any questions?
Just a few questions.
Well, I mean, state your silence. So if has something to do with any facts that are in dispute,
Not the
then
facts. I'm just gonna ask about questions that he was testified to with his relationship with his son, if that's okay. Okay.
I mean,
More
unless the defense has no objection. Yeah, that's fine.
questions then. Okay.
All right, I have some questions. Excuse me.
Sure.
Yeah, I have a few questions for you. So, first of all, these are not mistakes your son made. These are choices. He chose to get in a vehicle and drive, right?
Yes.
From College Station to here. So, were you ever aware of his relationship with the complainant? Did you all ever discuss his relationship with the complainant?
I asked him sometimes how was your relation, and he said it was a good relation.
So you're somebody that he can come to or could come to if there were relationship issues.
No, you never told me, but we have seen.
No, I'm talking about in general. Do you and your son have a close relationship? Because the defense has called you,
Okay.
hopefully, and I think he's calling you because you have a close relationship with your son.
Yes. Yeah.
He said he's 22 years old, so you've known him for 22 years. So what is your relationship like with him? Does he discuss with you any relationship issues he's having or any other issues he's having with his life?
No, just we talk a lot about the jobs and the school and all that, not the relationship.
All right, so my question is then, did he ever speak to you about his relationship with the complainant in this case?
No.
Did he ever ask you any advice about his relationship with the complainant in this case?
No, it just I would ask him how was your relation, and he said was a good relation.
Okay, all right, thank you so much for coming down.
Thank you. And Your Honor, at this time I call my client, Emilio Lopez.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Emilio Lopez.
All right, you may proceed.
So Emilio, throughout this process, let me back up. So have you been working, let's talk about right before this happened. So you were going to school. What was your goal to become?
My goal was to become a firefighter, and if that didn't work out, I wanted to pursue a career in either IT or join a trade.
Okay. And you were also working at various restaurants during this period of time?
Yes.
And during this period of time, were you being promoted at these restaurants to like supervisory roles?
Yes, and Blaze Pizza, I was a supervisor now, and they were in the talks of making me assistant general manager,
Mm-hmm.
but I had to quit due to a toxic work environment.
Okay. And then also when you you eventually worked at a barbecue restaurant and you were hired on as a management trainee, is that correct?
Yes,
But that company then failed,
yeah, it went under.
it went under. Okay. And then, are you going to be able to be a firefighter now because of these charges? Is that possible for you anymore?
Unfortunately, due to my choices, those doors, they've closed.
Okay.
But if after, like, whatever happens after this, my goal is to still go to college and pursue something that I can do.
Okay. And then the victim in this case, how long were you guys in a relationship for?
I believe it was 2 years, either a year and a half.
Okay. And when this relationship ended, was that emotionally disturbing to you?
Yes, it hit hard, really badly. And it was I was very distraught.
Okay. And during this time when you were distraught, at some point were you kind of off again, on again for a while?
It was only once. After the breakup, I decided to just work on myself, and I believe it was in October. She reached out to me saying that she wanted to get back with me, and I accepted.
But she continued to message you during this period of time after the breakup?
Yes.
Okay. And at this point, when you actually decided to go to her house, what was your intentions when you were going to the house?
I wanted to discuss. Again, I found out that during our relationship, our second time getting back together, she was, I guess, cheating on me. She was doing things behind my back with other people, and it just, I felt very betrayed and just ashamed.
Okay. But the purpose in driving from her house, well, first of all, let's talk. Did you have a key to her house?
I did was, when we got back together, I asked, like, hey, like, is it okay if I can stay over, find a job, earn some money, and then go back to college? Because the job in College Station, since it was near the end of the semester, a lot of students left, and there wasn't any jobs to go for. So I asked her if it's okay if I can live with her.
And how long did you stay with her?
I believe it was 2 weeks. Sorry, I believe it was 2 weeks.
And during that time, you got a key to her house, is that correct?
Yes, we first discussed, because I went with her to get a key, and it was at Walmart, but the key thing didn't work. And the next day I just went to get another one without her, 'cause she was at work.
Okay. But during that period of time, you were actually staying at the house for those 2 weeks full time.
Yes.
And was it your intention initially to stay longer than that?
By the end of I'd say, like, I would go home next year when my second semester started.
Okay. But initially you were gonna be there for longer than 2 weeks, is
Yeah.
that correct? Your plan initially was to stay there for how long?
I'd say I think I stayed there till, or
Not how long were you there? How long did you plan to be there when you were staying there?
I'd say 2-3 months.
Okay. Why did you leave after 2 weeks?
I discovered, so when we were together, we were both comfortable with each other, like taking our phones. You know, sometimes she would take my phone and just do whatever she wants with my phone. And I discovered that someone was messaging her, and I saw, and it was an unknown name.
Okay.
And
That's why you left?
yes.
Okay.
And that's when I found out.
When
about
you
that.
were going there, was it your intention to hurt or scare her?
No.
What was your intention when you got to the house?
Well, it was to discuss, like, as to why she did that to me, and if it was what we had, like, if it was genuine.
And why did you decide to do that in person or rather than over the phone?
Because in the phone, she would just not text me. She would ignore me, and I kind of I just wanted to discuss as to why she did what she did.
And how did you actually get into the apartment?
I believe she opened the door and that's when the fight occurred.
When she saw you, she was upset, correct?
Yes,
Did she start yelling?
I believe so.
Okay. And you did push her into the apartment, correct?
Yes.
And then at some point, were you trying to hurt her at any time inside the apartment?
No.
Well, again, why were but you guys were in physical contact, correct?
Yes.
And at some point you both fell down?
Yes. I believe it was in her room. From what I've known, I tripped on something because usually her room is very dirty, and I think I tripped either in a piece of clothing or just something that was near my foot.
Okay. I mean, and then her sister's boyfriend came and grabbed you, is that correct?
Yes.
And then what did he do to get you out of the apartment?
I believe she had me in a chokehold and he just dragged me outside.
And then when you got outside the apartment, why did you wait for the police?
I believe if I left, I believe they would take it as me fleeing the scene, so I decided to just stay there.
Okay. And were you honest with the police officer about going into her apartment and things like that?
Yes, I was.
And I mean, you understand that this would be scary for someone entering their house without them inviting them in?
Yes.
Okay. And how do you feel about that, the fact that you scared her?
I feel awful because then, even though I felt like I was wronged, she was still a good person, and she just never deserved what I did.
Okay. And I mean, are you willing to take all responsibility for what you've done? I mean, this whole process, you've been pretty honest about what happened. And are you willing to take, I mean, you obviously understand that you're responsible for doing this. Are you willing to take full responsibility for that?
Yes, I do.
And are you asking the judge to put you on deferred adjudication today?
I would like to, but I would also understand the other option.
Okay. But if you're given the opportunity to stay out on probation, will you make the most of that opportunity?
Yes.
And what will you do to make the most of that opportunity?
I would first, if I do get deferred adjudication, I would try and attempt to get a job, pay my dues, and then pay the amount of debt that I have to my family.
Okay. And I'll pass witness at this time.
Any questions?
Yes, Your Honor, I believe you went into the facts of the case, so I can ask questions.
Yes.
Okay. Now, Mr. Lopez, you testified that you went to the victim's apartment that night, correct?
Yes.
Were you invited by her?
No.
So this was your choice? Okay. When you got to the apartment, you mentioned, actually, no, before that, you said that you had a key to that apartment, is that correct?
Yes, that's correct.
And you said you made that key with her permission?
Yes.
She knew the whole time you had a key to her apartment?
She didn't know, but I assumed.
She didn't know.
I guess, yes.
Okay, she didn't know you had a key to the apartment that you made on your own accord?
Yes.
Okay. And when you got to the apartment that day, it was your intention to use that key to enter the apartment, correct?
I did, but I decided not to.
You did not to, okay. So then you met her at the front door, correct?
Correct.
She opens the door because she's wanting to go about her day that day, right?
Correct.
And you forced your way in with her into the apartment, correct? You pushed her all the way to the back bedroom, correct? There was a scuffle the whole way from the door to the bedroom, correct?
Yes.
Are you aware that you hurt her physically?
I believe so. Yes.
Are you aware that you scared her substantially?
At the time I did not.
Well, it would be reasonable for someone in her position to be very scared from what you did to her, right? Okay. Now, you said that the last thing is that you're wanting to take responsibility for what you did,
Yes.
and you understand that responsibility could include going to prison?
Yes.
No further questions, Ronnie.
Just argument, Judge.
Well, I have some questions.
Sure.
All right, so about this key, you were saying that you assumed you had permission to copy the key?
Yes, because I still had it
So why did you assume, I heard part of your testimony where you were saying, or correct me if I'm wrong, did you say that you went with her to make a copy of the key, but then something happened and you all couldn't do that?
Yeah, it was the day I came to San Antonio. She gave me the key and we both went to Walmart to go to the key thing, to copy the key, and it wasn't working. So we decided to just leave. And the next day I went to go pick a copy of the key.
Okay. And then my other question. So before this happened, how was your relationship?
I would say it, in my opinion, it was good. Obviously, there were some arguments here and there, but like other than that,
Was there any prior violence?
no.
All right. Any other questions?
No, Your Honor.
All right. So here's the thing. State is remaining silent, and I have to make a decision on whether or not I think prison is the right place for you. When I was in the DA's office, and I would have third chairs or second chairs sit with me, when we were looking at indicting cases, before I would take a case to the grand jury, I would do my own investigation, because I tell my students this as well. This is your job, right? Hopefully the police are doing their job. They do a thorough investigation. And then the stopgap from somebody getting indicted, right, is the state is supposed to do their job, do their investigation. It's not supposed to be like, okay, the police said they did this. I've read the police report. It appears that they did this. So therefore I'm done. Let me just take this indictment. So whenever I was in the DA's office, what I would do is I would read a police report and look at all the facts in it. And then I would be curious. And I would always tell people, sometimes the questions you have nothing to do with the price of peaches, but then sometimes you may see that, hey, this has to do with the price of peaches, and these are questions that need to be asked. And then my next thing would be is I would then reach out to attorneys and I would say, hey, this is what I would be willing to offer in this case, because I would speak to persons who were sitting with me. I said, okay, we've done our investigation. We believe that this person has committed an offense beyond a reasonable doubt. Then your job as a prosecutor, because you're supposed to be doing justice, that's what's in the code. Prosecutors are not to seek convictions, they're to do justice, right? So then I would ask the person sitting with me, I said, your next question before you even consider taking it to the grand jury, what is the end game? What do you think is justice? Do you think this person should go to prison, or do you think they should have probation? If I felt they should have probation, I would reach out to the defense attorney if they had one at that time and say, hey, I've done the investigation on this. Think this person should have probation? Are they willing to come to an agreement? And then sometimes I would say, hey, this person deserves to have prison. I would reach out to the attorney. This is what I'm offering. And whatever I offered, if I was saying the offer is 5 years prison, if somebody would end up going to jury trial, and sometimes people would get upset with me, they'd go to jury trial and they would be found guilty. And you know what I'd do? I'd stand before the jury doing punishment, and I would ask for 5 years, because that's what the cases were. I would never do this thing where, okay, you want a trial? You go into trial? Fine. I'm no longer offering 5. I'm going to ask this jury for life, because to me, the case is worth what it is worth, for want of a better term. So in your situation, I don't have a crystal ball, right? I understand that you're young, pardon the expression, dumb, in a new relationship, driving all the way from College Station because you believe the person that you're in love with was unfaithful to you. And I try to tell young people, all of these relationships, some of them will last forever. Some of them are crazy, like Romeo and Juliet. I never understood in my school why people were gaga over Romeo and Juliet. I'm like, this is some stupid nonsense where they're killing each other because they're in love. And then when I did my research and discovered how old they were, I was like, oh my gosh, didn't their parents say anything about this relationship? So my question is whether or not, for me, is whether or not you should go to prison. The state is silent. So the state is not telling me yes to prison or no to prison. So I got to figure that out. Right? And this is what I am going to do. He's saying that there has been no previous violence in this relationship. So that's what I have to go with because I don't have any other evidence before me that suggests something differently. So here's your choices. These are the only choices you have. Don't come to me with a separate choice. People say that in my court, probation is very difficult. I try to give people the tools they need to be rehabilitated so they won't be back before another court or that I'm passing the problem off to society. So you have a choice. Your choice is I can send you to prison for 2 years, or I can place you on probation and I'll place you on probation for 8 years, and that's deferred adjudication. Those are your two choices.
I would go for probation.
All right. So, and here's the thing with that. I've seen a lot of cases that have come before me, some cases that are worse than yours. Sometimes people are offered deferred for cases and I don't understand why they were offered deferred. But this is where we are. So this is what the court is going to do. The court is going to sentence you to 8 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs. There's to be no contact with the complainant. That relationship is over. You don't have any children together. You don't have any property together. There's no need to call her. There's no reason to text her. If accidentally you receive a text message from her or phone call, that number should then be blocked. You understand?
Yes, ma'am.
It's over. And don't get into any other relationships until you work on yourself. Because the fact that somebody may be unfaithful to you or somebody doesn't want to be in a relationship with you anymore shouldn't send you into a spiral. There is to be 200 hours of community service restitution, proof of employment within 30 days, no employment as a home health care provider or with minors. And then if he obtains a higher level of education or trade school certificate, the community service hours will be deemed satisfied. Let's see what else is here. There's a $1,500 fine that will be probated. Probation, is there anything else?
Field visits, judge, and possibly anger management.
Thank you. Field visits 1 time per month for 6 months. Anger management. And is he currently in Bear County?
No, Judge, right now he's residing in Bryan, is that still correct?
Yes.
But it's your intention to move to your father's house, is that correct, or? are you planning-
If I, yes, in my father's house.
And that's in Brownsville, Texas?
Yes.
And which county is that?
I believe it's Cameron County.
All right, so are you in Bryan for school or something?
Yeah, I was going to Wayne College.
He was going to school, Your Honor, but then what happened is because he picked up these charges, he couldn't proceed with that program because of his arrest. But his intention to roll, I talked to him earlier today, it's his intention to re-enroll in school. And I think he also wants to get a job at the same time, so.
All right, well, they won't do, you don't need a transfer, I don't think, to attend college. So the court will do anger management, a transfer to Brownsville with his father, and he's allowed to attend college. Your client needs to fill out that.
Thank you.
Anything, I know you're silent, but are there any other conditions you would request?
Maybe a tap eval and
All right, tap
just to get
evaluation.
that.
All right, thank you. Tap evaluation out of custody, follow recommendations. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. You better start making better choices. And let me explain something to you. The state was offering you a cap of 5 salary. You decided to do deferred adjudication. From here on out, everything you do, you need to ask yourself, could this result in me potentially going to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. So you had your liability limited to 5 years. Now your liability is potentially 20 years in the prison. Do you understand?
Yes, ma'am.
All right, good luck to you. Is there,
Victim impact statement. Yes,
all right,
ma'am.
if you stand over there. All right, you may proceed. It says sit and wait for probation. And Cindy, let me know when you're ready.
Okay.
Yeah, I just want to verify with the plea bargain.
Who's here on Jacob, Jesus Leal? Thank you so much. It's one of those days.
Thank you.
And his cases still have not been indicted, correct?
Correct, Your Honor.
Have you spoken with the state?
I have, Your Honor.
So did they give you, okay, did they give you an idea?
They weren't, they asked me to request that it be sent to grand jury, that they're not sure. 3 of the 4 cases are victim cases that they'll have to reach out, and then One of the cases is still pending labs.
All right. All right, so what's gonna end up happening? Who's the prosecutor on this?
I spoke to Miss Galloway.
All right. Oh, Ms. Galloway, so in this case, there are not gonna be any more settings in court until it's indicted.
Okay, thank you, Judge.
All right, thank you.
Mr. Banks is the intake prosecutor and he is in the process of collecting the evidence. And I did double check on that. So thank
All
you.
right. So the next time you'll be in court will be if these cases are indicted and you'll receive a card in the mail. You need to make sure that your appropriate and proper address is on file. Otherwise, it's going to be sent somewhere else. And a warrant's probably going to be issued for your arrest if you don't show. You understand?
Yes, ma'am.
All right. Thank you.
Yes, ma'am.
Thank you, Judge.
Thank you.
Yeah.
Okay. Well, tell him he's gonna go to trial in his. All right, Cario. Oh, thank you. All right, Camaria, who is that? Hi, how old are you? All right, so there are consequences for choices. When a jury comes up this afternoon, you're gonna be in trial in those clothes since you didn't want to dress.
Judge. Sorry, is that Renee King?
Yes.
Who's gonna be?
I'm sorry.
It's gonna be.
Okay, all right, thank you. See, Jason, I'm trying to teach 18-year-olds there are consequences for action.
Both got a busted on yourself and worse than a trial.
Thank you.
There you go.
I know, I'll cook it.
Winston, Washington, Bexar.
You have to do new paperwork, because we have different offer, but I don't know for oath service. Not offer. I think she had it. Oh.
All right, Norma, on Leal. Ah. All right, who's here on Tiffany Martinez?
Tiffany Martinez?
All right, so she's scheduled for jury trial today.
Yes,
All right, 1:30.
we're not ready. We do have a motion to continuance on file.
All right, if you can have them pull the motion for me. And then I'll take you up.
Okay.
Right. Who's here on Jalissa Cerniel? All right, Jonathan De Hoyos.
Or your honor.
Good morning.
Sharp Brown from Mr. DeHoyos, we're ready.
All right, is this an application?
It is for deferred recommendation.
All right, probation, this is an application. Where's your client?
Coming up.
Nobody wants to approach with their attorneys anymore. What's going on?
Yes, I guess he wants me to take the deal and be on probation for 6 years.
That could be it. That's it. Way to go. All right, court is calling 2025 CR 0034998 State versus Jonathan De Hoyos. Could I have parties announced?
Jason Gearhead for the state, Your Honor.
Sean Brown from Mr. DeWitt, Your Honor.
And are you Mr. De Hoyos? Counsel, have you received all discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. De Hoyos, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
I believe we are, Judge. Okay, thank you.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with evading arrest detention in a vehicle as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is, Your Honor.
Mr. De Hoyos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at a $2,000 fine. State recommends deferred adjudication. This is to be run concurrently with the case from Guadalupe County, and it's case number 231390CRC. Did you understand that to be the plea?
Yes, ma'am.
Defense?
That is our agreement. Yes, ma'am.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Excuse me, Your Honor?
Have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 6 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? You need to speak up?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. State Exhibit number 1 with all its attachments.
Judge, I've reviewed that with my client. We have no objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We'd ask to waive the PSI, Your Honor.
All right, anything you wish to say on behalf of your client?
Judge, he accepts responsibility. Obviously, we're here today. He's working. He lives with his family. He's got a good support system. Understands he made a terrible mistake and choice, and we're asking him to follow the agreement that we have with the state.
All right, how old are you?
23.
All right, why are you doing this?
It was a bad decision.
Why are you making bad decisions that could perhaps result in your death and other people's death?
Hanging out with bad people.
Now, if I talk to the person who was the passenger in the vehicle, if he were before me charged with this offense, which he can't be because he wasn't driving, but if he were charged with this offense, you know what he'd say? I was hanging around with bad people, and I'd say, well, who are these bad people? And you know what he would say? You are. And in the big scheme of things, you're the one who was driving. Did he have a gun on you making you drive? So you're the bad person, right? You still have a chance to change your ways. How did you get to court today?
Truck.
I'm sorry?
My truck.
All right, so what I can tell you right now, today is the last day you're going to be driving that truck. You know why? Because as a condition of your probation, I'm not going to allow you to drive until you complete the defensive driving course. Do you understand?
Yes, sir.
And after all of this happened, you live with your parents?
Yes.
They didn't take the keys to your vehicle and say you're not allowed to drive because you're not responsible? So I'm going to do it. All right. Are you employed?
Yes.
What do you do?
Auto detailing.
All right, you're gonna have to take the via bus or get an Uber because you're not allowed to drive. Do you understand? Use words, okay.
And Judge, that's until he takes the defensive driving class and provides certificate to probation.
Yes.
Okay, thank you.
And there's going to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. And when you're drug tested today, what are the results going to be?
Positive.
For what?
For no drugs.
I'm sorry, what?
For no drugs.
Just alcohol, he said.
Oh,
Oh, just alcohol?
I don't do any alcohol.
Well, I mean, what are you going to be positive for? Speak
Mayor,
now, forever
we're
hold your
elected.
peace, because you will be tested today. So what is it going to be? If you use earlier this morning, if you use before I'm placing you on probation, that's not a violation of your probation. If you use after, it's a violation. So what are you going to be positive for? Your attorney wasn't with you using drugs. You were with whomever you were with. He doesn't know. So what are you going to be positive for?
I mean, not down, drink, or smoke, or anything like that.
So you're saying when I send you to go do a UA, you're going to not be positive for any drugs? You need to use words.
No.
So you're going to be negative. All right, I'm going to want a UA today. And if the UA is positive, what's going to end up happening is you're going to go into custody. You're going to do a TAP evaluation in custody. You understand? All right, so there's be a UA today. If he's positive, then you'll report back. Well, you're going to have to report back to court anyway. So if you're going to be positive from the testing, you need to make sure that your parents or somebody can pick up your truck for you. You understand? So there's a UA today. No later than 1 p.m. There's to be the defensive driving course. $100 hours of community service restitution. If you obtain some sort of trade school certificate or higher level of education, the community service hours will be deemed satisfied. There's to be no contact with I saw his name.
Gilbert Latta, Your Honor.
Thank you. There's to be no contact. Thank you. With Gilbert Lara. Field visits 1 time per month for 6 months. And it is to be a $2,000 fine That will be probated concurrent with case out of Guadalupe County, number 231390 CR. They're asking for 6 years deferred adjudication. You want to speak to that?
Yeah, Judge, I would ask that he get the 4, you know, I think 4 would be sufficient under the circumstances of this charge.
All right, 4 years deferred adjudication.
Thank you, Your Honor.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, in just one moment. There's to be a TAP evaluation out of custody if the defendant tests negative. If positive, then the TAP evaluation will be in custody. And there's to be no driving after June 10th, 2025 at 5 p.m. All right, I'm sorry. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You can't be racing through the city like this Fast and Furious, because even that, when they have controlled movement, people still are injured, and you're not a professional. You could have killed anybody. Your passenger could have been killed. And if your passenger would have been killed, you know what? The state would have been looking to file charges. You understand?
Yes, ma'am.
Or I should say, receiving charges from the police. And this would have been more than just an evading arrest and detention in a vehicle. All right, good luck to you.
Thank you, Judge. May I be excused?
Yes.
Thank you.
All right, James Weed. No, I'll do it. All right, thank you. All right, Tiffany Martinez.
You used my full name. It kind of scared me.
James Weed.
Yes. Put the middle name in there. I'm in real trouble.
All the way up here to the left line, make sure you speak loud enough for the court reporter to hear you.
All right, who's the prosecutor on this? All right, the court is calling 2024 CR 008238 State versus Tiffany Martinez. Could I have parties announced?
Jason Gearhead for the state, Your Honor.
Jim Wheat for the defense.
And are you I'm sorry, and are you Miss Martinez?
Yes, ma'am.
All right, you're scheduled for jury trial today. Defense, you filed a motion for continuance?
I have to.
Yes. And
Yes.
what is the reason?
It is something at this point, we are looking into the relationship between the two co-defendants further. Information has come up over the last week that I need to go into further, just to get not just her thoughts on it, but also outside resources.
All right, and state, do you have an objection to the motion for continuance?
No, Your Honor.
All right. All right, the motion for continuance will be granted. And then what we will do you have an idea of what's a good setting for you all to agree on, a setting for jury trial?
On this one,
Mhm.
I don't know.
All right, so then counsel, what I'll need you to do is I'm gonna either need you to zoom in. The coordinator had a meeting that they had to attend. Well, you know.
Can I
what?
email her?
No,
Is that
this is
okay?
what I'll do. So you can leave. I'm gonna set this for a date. And then that will give you a chance to look into what you need to look into.
Okay.
And then this will be the date that you come back to get your jury trial setting. All right, thank you. All right, so I'm gonna have you come back on July 21st.
Okay.
And that will be at 9 a.m. And it will be to obtain a trial setting.
Okay.
All right, once you sign the reset form, bring it back to me, please.
Thank you, Judge.
Thank you. Yes. I'll take care of it.
You want it back to you or to the clerk, Judge?
Oh, to me. Did you take your copy?
I haven't yet.
Oh, yeah, take your copy.
Okay.
Oh, you're back, Norma?
Yeah, I gotta go in a minute. I'm
Okay,
just gonna leave her a message.
This will work just fine. Thank you, Judge.
thank you.
You would want to. Is that big enough? Sorry. I was just giving them a message.
No problem.
Mason Washington.
All right, Marco Marino.
Mason Washington. Yes, he's on the sexual assault case.
And counsel, we'll just put on the record his finances, so there's no need to discuss the motion. I just need his finances for the record. Court is calling 2024 CR 006824 State versus Marco Marino. Can you raise your right hand for me, please? I'm sorry. Defense, state your name for the record.
Christine Brown on behalf of Marco Moreno.
And state you're not needed for this hearing. And are you Marco Marino? Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. State your name for the record.
Marco Moreno.
All right, when's the last time you were employed?
I believe it's March 11th. 2024.
All right. And do you have any bank accounts,
I do.
any savings in your bank account?
No.
So they're keeping it open even though you don't have any money?
I think I still have. I'm not sure.
All right. The last time you reviewed your account, how much money approximately would you say you had in your account?
It's less than 50.
All right. And has there been any family members who put money on your commissary?
My mom and family.
All right. Do you currently have money on your commissary account?
I don't know. I don't know.
All right. The last time you checked, how much money did you have on your commissary account?
56 cents.
All right. All right. Thank you.
Thank you.
Yeah. All right. Thank you. Deputy Laura, we're finished with Mr. Marino. And they'll give you a copy of this in the back.
Okay. What is the ruling?
Oh, I'm granting it.
Okay.
Yes.
Okay, thank you.
Sure. All right, who's here on Barry? Marquise Barry. And is there an application?
Yeah.
Court is calling 2023 CR 3465 State versus Marquise Trayvon Barry. Can I have parties announced?
Megan Galloway for the state.
Angela Blake, attorney for Mr. Barry.
And are you Mr. Barry?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Barry, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, we move to proceed on the lesser included offense of possession of marijuana 2 ounces to 4 ounces, the Class A misdemeanor.
Any objections?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand the state is proceeding on the lesser included offense of possession of marijuana 2 ounces to 4 ounces as a Class A misdemeanor? Range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, The fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Berry, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense. They're asking that your punishment be assessed at 18 days in the Bexar County Jail. There's a $500 fine. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Yes, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State offer states one in attachment.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. One moment. And let me continue the review. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We ask for time search, Your Honor.
All right, the court will find you guilty, sentence you to 18 days in the Bexar County Jail. Give you, there's a $500 fine, time and money to rank concurrent. And the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Do you have any children?
Yes, ma'am. I have 2 and 1 on the way.
All right, and what are their ages?
3-year-old and 9-year-old.
All right, so let me just tell you this. A 3-year-old and a 9-year-old should not be driving around in a vehicle that smells like marijuana. Now, your 3-year-old and 9-year-old, do you love them?
Very much.
How much do you love them?
Everything gonna be
All right, so how long have you been in jail?
a week now.
All right, so is marijuana worth you spending a week away from your children? So you're gonna have to make changes, and before you transport them around in your vehicle, you need to take that vehicle, have it detailed, it'll probably cost $365. Have it detailed and have that scent removed, because their brains are steadily growing, and you don't want it to be impacted by marijuana smells, right? And you don't want the 9-year-old feeling embarrassed if people at school know that his father is using marijuana, because children know what it smells like. And I know people say marijuana is no big deal, but in Texas, it's still against the law unless you have a prescription. Do you understand?
Yes, ma'am.
Now, when you're released from jail, if you need anything, if you can't kick using marijuana, if you come back here and I'm here, I'll help you find a place that can help you. All right?
ma'am.
All right, good luck to you.
Thanks, Judge.
Who's here on Chase Lopez? So
Oh, Your Honor, I was gonna say good morning, but I think we just
Oh, yeah.
passed that.
we have passed that. So many things happened today.
Yes.
All right, so where are we on discovery?
I believe that we have all of the discovery. I'm double checking with the medical records that the state has, just double checking they're the same that have been uploaded. We have conferred and received an offer. We'd like some more time. As you can see, my client is a little on the younger side, and
Mhm.
so we'd like to really weigh the options of the offer that the state has given us against the evidence and risks associated with trial. So if we could get 30 days, Your Honor, that would be wonderful.
Okay, how old are you, sir? All right. See, now, when we say that other people are younger, that, I don't know, that's saying something about my age.
Yeah.
As we get older, when you're in your 20s, you think somebody in their 60s, oh my gosh, that's all. But then as you approach that, you're like, no, 60 is not all. Yeah.
I take it back. Yeah, no.
All right. So what I will do is I'll recall you for July 29th.
29th? Yes, Your Honor.
And that will be your plea deadline date. So once you sign the reset form, you can be excused. And I will give you a copy of the reset to sign, and then just return it back to me, please.
Understood.
I don't know why they would have a court coordinators meeting
Right.
during the daytime.
Yeah,
I'm
around
just-
lunchtime.
I'm just throwing that out there.
They can coordinate court dates, but not their meeting.
Hey, I didn't say that.
I know, I'm joking, I'm joking. Okay, thank you, Your Honor. I'll get it right back to you.
All right, thank you. What page is Lopez on?
I don't
Oh. Oh, I found it. That's okay. Who's here on Roger Blanco?
Your Honor.
Good morning.
Sure.
Yeah, good afternoon. Yeah, we're gonna be here, and then once lunch arrives for the jurors, we're gonna take our recess.
Sounds good.
All right, so
So-
you were recently appointed.
Yes, this is our first appearance.
No gum chewing. I would love to be chewing gum right now.
This is our first appearance, Judge. I'm working on discovery, and we will see what we can do next setting.
All right, I'll set this for discovery. June 22nd, I'm sorry, July 22nd. Is that good for you?
Beautiful.
All right, I'm gonna give you the reset form, and once you sign the reset form, please return it to the court.
We will do that, Judge.
And counsel, did you get on his case that is the first degree? It's a PF case.
Yes.
All right. And we'll just set it for discovery, counsel.
Okay.
Thank you, Judge. Return that.
All right, thank you. All right, who is here on Dina Acosta? Yes. All right, are you all ready to proceed with sentencing?
We are, Judge.
I'm sorry, just 1 second. Do you need a copy?
Oh, no, Your Honor, I didn't. I just wanted to make sure you knew before we could be excused.
Oh, yes, you can be excused.
All right,
so
thank you, Your
much.
Honor. All right, you'll have a good one.
All right, the court is calling 2024 CR 0075332 State versus Dino Acosta. Could I have parties announced?
Jason Gearhead for the state, Your Honor.
Scott Simpson from Mr. Acosta.
And are you Mr. Acosta?
Yes, ma'am.
All right, we're here for sentencing. The court ordered that half of the restitution be paid before sentencing. So has that been completed?
We have, I believe the court got a copy of it too. This is my client's copy.
Sure.
He paid $8,000 today. Andrew signed off on it.
Okay.
So that was the amount that was in the plea, 8,000 of the 16,500.
Okay.
And it has been paid. He still owes 8,500. He knows that, which is part of our argument as to, because it's an opposed plea, Judge. So that's part of our argument as to why you should grant probation.
All right, so the total restitution is 16,500, but he paid 8,000 of that, correct?
That is correct, Your Honor.
All right. I saw where you had wrote on that form that he owes 10,000. I'm like, is my math off?
That's for us.
Okay. Oh, sorry.
We
Yeah.
haven't been asking him to pay us because we wanted the restitution.
Excuse me, Mr. Green, is Mr. Green here? You know, that was from, well, you know what movie I'm talking about. Okay.
I do.
All right, let me find the plea bargain agreement. All right, you entered a plea, and according to your plea bargain agreement, the state is opposed to your application. And restitution was to be to Andy Hydrick and Rocky Hill Equipment Rentals. And there's to be a $2,000 fine. State, he's made an $8,000 payment. Are you still opposed?
No, Judge, in lieu of the fact that he made $8,000 and showing improvement on that, the state would be recommending a probation there period.
All right, are you recommending the deferred? Because he's requesting deferred.
A good conscience, I can't recommend deferred on this, Judge. The reason being is just because of the history.
We applied for both, Judge, and just an abundance of caution. He does have felony convictions already. I do need it's the person that is owed the restitution is Hector Gabaldon. The equipment that was stolen was received back by the aforementioned people that you talked about. It just he sold it to Hector, and the Hector had to return it to those people.
All right.
So Hector's the person getting the restitution.
Okay. All right, this is what the court will do. The court is finding you guilty. The court will sentence you to 10 years in the prison, suspended and probated for 8 years. There's a $2,000 fine that will be probated. There's to be restitution, if any, to Rocky Hill Equipment Rentals. Is that the appropriate person, counsel?
Put that down just in case, but they already said they didn't have restitution, but then we need to add Hector. And the last name is spelled Gabaldon. He's the one who's actually out money, Hector Gabaldon.
Right, so Andy Hydrick is not owed any money?
No, they got their equipment back. From what I thought.
That's an individual, I believe, with Rocky Hill, Judge.
Okay. All right, so I put down Rocky Hill Equipment Rental, so if something pops up, then it will still end up going to the owner, Andy Hendrick.
Thanks, Judge.
So the court will note that the defendant has paid a total of $8,000 upfront. Could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Acosta?
All right, so Mr. Acosta, based upon the restitution amount, at sentencing, I was told that restitution amount was $16,500.
Correct.
So you paid the $8,000, so what's due is $8,500. How much are you able to pay per month towards the restitution?
I could do anywhere between $1,000, if that is.
All right, so here's the
sufficient.
thing, this is what I tell people. I just want to know what the amount is, and whatever you say the amount is, of course, if you tell me $20 a month, I'm going to say absolutely not. But whatever the amount is, that's what I'm gonna put in this order. So if it's $1,000 and you're 100% sure that it's gonna be $1,000, then I'm gonna order you to pay $1,000 a month towards restitution.
Understood. Well, in that case, $500 would be sufficient. That way I meet up to my expectations.
All right, he's to pay restitution in the amount of $500 per month. Proof of employment within 30 days, no employment as a home health care provider or with minors. There's to be the theft course, a $2,000 fine that will be probated. Field visits 1 time per month for 3 months. 200 hours of community service restitution. Regular reporting by Zoom or in person, and regular random UAs. Probation, is there anything else he needs?
Yes, Judge. So as far as the restitution, the Rocky Hills Departmental, according to the PSI, they're not requesting any type of restitution. Also, Mr. Acosta indicates, and I think the court is aware that he travels for work. I just need something to put in his conditions, giving him permission for that.
All right.
Works as a welder out on one of those deep sea rigs.
All right, so I'll put, the defendant is allowed to travel for work. And then there's no restitution then to Rocky Hill equipment. So the only restitution will be to Hector Galbaldo.
And Judge, I just wanna confirm, Mr. Costa, when he does travel for work, he goes everywhere and he's gone for an extended amount of time. Is it okay that I make sure that that's in there?
Yes. Is there anything else?
Nothing further from the defense, Your Honor.
Anything else you need from the court?
I just want to say thank you for the opportunity. I know I did make a mistake, a bad decision. I don't want to call it a mistake. It was the decision that I made, and it was a bad decision overall, and I'm paying for the consequences, set my family back. But we're looking to do better. And I do want to say thank you to the state as well for giving us this opportunity. We know we were a purpose.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, I did.
All right, do better.
Yes, ma'am.
Thank you.
Very well. Thank you,
Thank
Mr.
you.
White. You have a good day. Thank you.
Who is here on Marcus Butler?
Walkway clear, please.
All right, counsel. What is happening with Mr. Butler?
Yes, please.
The state has given me all the discovery in this case, Judge. I have an appointment with him this Friday to go over everything.
Okay. All right, how old are you, Mr. Butler?
I am 46 years old.
All right, I'm gonna set his plea deadline date for July 22nd. Let me give you a reset form. Once you sign it, bring it back to the court.
Thank you, Judge.
You're welcome. All right, who's here on Curtis Wilson? All right, where's Mr. Wilson?
State tells me he has left the building.
All right, so I'm gonna issue a warrant for his arrest.
Judge, I'm asking that he be remanded without bond.
I'm gonna issue a judge's warrant and remand him without bond. And we're gonna go on the record. Court is calling 2024 CR 2927B, 2024 CR 2928B, 2024 CR 3099, State versus Curtis Wilson. Can I have parties announced?
Megan Galloway for the state.
Blood written hour for Mr. Wilson.
All right, this hearing is scheduled at 9 a.m. I did notate that I saw Mr. Wilson in the courtroom. Did he show up for court today, counsel?
He did, Judge.
All right. And Deputy, could you make an announcement for Curtis Wilson in the hallway, please? All right, thank you. All right, defense, do you know where your client is?
Do not, Your Honor.
All right, state.
Your Honor, I'm asking that the court issue a judge's warrant and remand the defendant without bond.
All right, the court will issue a judge's warrant in each cause number and remand your client without bond. And the court did today receive a violation report. Counsel, have you had a chance to review that?
Given to us about an hour ago, Judge.
All right. All right, thank you.
Thank you, Judge.
Sure. All right, and Adriana? Yes, ma'am. I gave you Mr. Wilson's file, because those are warrants
Yes,
that need to be issued immediately.
Yes.
All right, thank you. Who's here on Mason, Washington? Yes.
All the way up to the black line, make sure you speak loud enough for the court reporter to hear you.
Your Honor. May I just say one
Yes.
thing before we start? Your Honor, due to the nature of the charge, my client is asking if maybe we could be a little more quiet
Sure.
when it's read out.
So, did he enter a plea or no?
Previously, we did not get through the plea, Your Honor, but we've received a different offer then.
So, are you all going to be accepting the plea or no?
Yes, Your Honor.
All right, so have you already filled out the paperwork?
Yes, Your Honor.
I don't have the paperwork for this.
I did just hand it to.
Just handed it to me.
Yes.
You didn't tell me. I had 3 other keys in front of me.
Oh,
I didn't know. I'm so sorry.
no problem.
So this is how you vote.
Yeah,
No problem. We'll get to it. Just have to
Thank
see
you
it.
so much.
Partner gets back.
Here on Tyrell Benjamin. Who's the attorney for Tyrell Benjamin? All right.
Judge, I've been conferring with the DA's office about a potential offer change and we didn't get the offer change that I was looking for. So we'd like a reset today, so potentially we can take a plea next setting.
Oh, right.
And previous date that I had from you was July 22nd.
All right, that's gonna be your plea deadline today, although today was supposed to be for disposition, but since a new offer has been tendered, this case will be resolved on that date, either with an agreement being reached or either a jury trial. You understand?
Yes, sir.
All right. All right, once you sign that,
I'll get it back to you.
thank you.
Thank
Thank you. You're welcome. Thank you for dressing appropriately for court. Who is here on Jamarian Greer?
I'm here, Your Honor. Your Honor, once again, good afternoon. I was conferring with the state, they've given us a new offer. We're considering that new offer and or a jury trial potentially.
All right. Your plea deadline date is gonna be July 22nd, or either you're gonna be in trial. You understand? So this case will be resolved by that date. Oh, bring that back to me once you sign the paperwork, because I need to put it in the system.
Thanks, there for you, Judge.
There you are.
Thank you, Judge.
You're welcome. Thank you. Who is here on Eddie Law Outlaw? Yes. All right, where's your client?
He discovered he has an at-large misdemeanor case that was filed. He's at the jail.
Well, I will tell you, I didn't have him down for today, at least on my docket sheet. Let me double check. Yeah, but I don't know if he should be.
Mixed up in the shop. It's a sign from the university.
Let me see.
Couple more.
Oh, no, it is today. All right, so where's he?
Bear County Jail.
Ah, okay. So today is plea deadline date. What we'll do is we'll have him recalled for Thursday.
Thursday.
All right.
Thank you. Thank you, Judge.
All right.
Yeah, or just
Oh, just make sure you're here, because is he planning on releasing?
That's the hope.
All right, so it'll be on the 12th, okay?
Thank you, Judge.
All right, if you can bring their client out. Yes,
Okay, let me get first.
thank you. It's a question.
Okay. He's not in very confident.
All right, we'll see what's on.
Even a jail, but not in Bexar
Bay County Jail.
Mason.
I have one that's going.
It was like a 2 page. I don't have Mason Washington. Just 1 second. Yes.
Yeah,
That wasn't Mason Washington? No, you mean the guy in the t-shirt?
Yes.
No, this, I don't think his name is, excuse me, public defender. Who has the client who's wearing the t-shirt? Where did she go?
She's not here anymore.
That was Miss Christine.
No, that paperwork I handed back,
Okay.
because it was 2 files, yeah.
Yes, thank you.
All right,
Had to.
I was like,
He had to go.
Judge,
He had to.
I spoke with Christine McDonald from Mason, Washington. She said that she had to step out for mental health court staffing. And she said if at all possible, she can go back in the afternoon.
yes, that's fine.
I'll let her know. Thank you.
All right, thank you.
Everything's ready.
I'll let her know.
Thank you.
Okay, no problem. Yes, they work. Over there, grab the alarm. Which yours? Oh, I'm out of staplers. Here, it's the first one I went to.
You need staples.
Yes. Thank you. Oh, you'll just give it to council for both sides. Thank you.
No, not with that. With that. No, but with that.
Already indicted. Plus presenting.
Yes.
All right, so once, all right, so if I can have that back, please.
Got it.
Just on that. Or to.
It's in the box. Yes, thank you.
Thank you.
Thanks.
All right, we're back on the record in 2024 CR 006-930. State versus Alexander Rodriguez. Can I have parties announced?
Back down and Rick Pena for the state.
Candace Patton, Rosa Giovenco for Alexander Rodriguez.
And you're Mr. Rodriguez? All right, the court has received the following question from the jurors. Since outcry to 2022, did Emily go on Rodriguez family vacations with Alex? Have both parties had a chance to review the question? State?
Yes, Judge.
Defense? The court proposes the following supplemental charge. With reference to your inquiry, you now have before you all the testimony, exhibits, and evidence that was admitted, and you are instructed to continue your deliberations. Any objections to that as the answer, state?
No objection from the state.
Defense? Any objections to the court sending the question and answer back to the jurors through the deputy?
No objection from the state.
All right, thank you. All right, who's here on, oh, I'm sorry, we have the interpreter. Who are you here for to interpret?
I did. Carlos Vasquez Savania.
Have you turned in your paperwork?
It's not for that, Your Honor.
Well, have you had them pull the phone to give it to the court?
Carlos Vasquez Savania.
So that will be a no, right?
No, I
Okay.
told her about it.
I'm sorry, sir, there was like 5 or 10 people in front of me, and you did probably? You're just there.
All right, thank you.
We just need to approach the judge on the plea offer that was made.
All right, Carlos Saldana. All right, and he only has one case?
Yes, Your Honor.
All right, so what is happening with this case?
Judge, I believe the defense counsel had a plea worked out, but I don't believe that the defendant wants to take the plea any longer.
We'll go on record, Judge.
Sure. Court is calling 2025 CR 003338 State versus Carlos Saldana. Can I have parties announced for the record, State?
Jason Garahan, Your Honor.
Roberto Vargas for a defendant. Just to refer,
Just 1 second. Are you Mr. Saldana?
Yes.
We have an interpreter here. Can you raise your right hand for me, please? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Carmen Tarragona Sáez.
Thank you. There's something you want to say, counsel?
yes, Judge, just to refresh the court's memory, at the last setting, they had made a reasonable, very reasonable plea offer, but we didn't have a Padilla letter, so we reset it for a Padilla letter. Having done the Padilla letter, you cannot go forward with the plea offer and just for jury trial.
All right, so he'll go to a jury trial. So I'll see you back here this afternoon.
Judge, not prepared today. Today was not set for plea, it wasn't set for trial.
No, this was set, and then you were in trial somewhere else. And then it was reset, I mean, it was set in May. And then you were in trial somewhere else. Then it was set yesterday, and you were in federal court, and now we're here. It's a possession less than a gram case. So we'll see you at trial this afternoon.
Okay.
All right, thank you.
Thank you.
And counsel, he can do a jury trial or bench trial, whichever you prefer. Or he prefers, I should say.
Your Honor, may I beg to?
Yes, thank you.
It's my pleasure.
Deputy, do you know if lunch has arrived for the jurors?
Yes, then we have to.
Everything's here. All right, we'll take our recess at this time. All right, ladies and gentlemen, the court is going on recess. The staff needs a break. And we will be back at 2.